Somewhere. All righty, it will happen. I do. Thank you. All right, thank you, Megan. All right, who's here on Christopher Mariscal? The equipment's not working today.
Oh, no.
Well, it's they're trying to make this Thursday a Monday, but we're not going to allow it to happen. All right, so where are we on this case with regards to discovery?
We just got onto it. So I think it's fairly recent, like new as far as discovery.
All right. So was there blood drawing involved in this or no?
I believe so.
All right. They took your blood? All right, Ms. Ferguson, on this case, I need a 30-day reset for discovery.
Judge, that case is set for March already. We took a violation.
Oh, well, could I have a copy of the violation report? On Mariscal? There's no attached violation report. We are not going to let this day become a Monday. Even if it is feeling like a Monday, we are going to, what we're going to do is we're going to be happy because it's Friday's Eve. All right, and defense and state, there's a juror that's missing, so we're just waiting on a juror.
Thank you, Judge.
All right, they're going to print out another. And have you conferred with the state on the violation report?
No, I have not. Your Honor.
All right, you all need to confer. All right, just have a seat.
Your Honor, she went to her vehicle and she left her phone behind, so we can't call her. So she's going back to the check. That's a checking in the outside, so we're just waiting.
All
But
right.
she is here, just not.
Okay, awesome. Who is here on Wilfredo Maria?
That we approach.
Yes.
Good morning, Your Honor.
Good morning. Thank you. Oh, no, it's nobody's fault. All right. Good morning. How are you doing? Oh, that's good. I tell you, you're looking better.
Yeah.
So that's a good thing.
You changed my life, I live.
Okay.
It's for
All right. So are you doing your AA meetings?
He's got him in his pocket.
Okay, awesome. So I hope you're learning something and they're helping you with your sobriety.
You just hold on and keep going.
Okay.
All right.
Yes, Judge, he says it's helping him, so we
All
appreciate it.
right. You're gonna have to keep that up, okay?
Yeah.
All right. So yes,
My officer called me to protect this paper.
I'm sorry.
The official, the probation official, take this paper.
Yeah, you can just get it.
All right. So where are we on this
Judge-
case?
Judge, we
Yes, I think we just need to set it for a plea deadline.
Yes, that'd be fine, Judge. Thank you, Judge.
All right, Ms. Ferguson, on this case, I need a plea deadline date. It's Marrero.
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 Yeah.
All right, I can't roll my R's. I'm gonna work on that though, I promise you.
Okay.
If I could have 3 weeks reset for a plea deadline date.
Thank you, Your Honor.
You're welcome.
Thursday, March.
All right, March 27th.
Thank you, Your Honor.
Thank you.
I'm gonna sign this.
Oh, okay.
All right, are you all ready on Mariscal?
Conferring right now, Your Honor.
All right, thank you.
I don't know, I'm not that.
All right, who's here on Luis De Leon?
We are, Your Honor, we're ready.
It's just a set for sentencing. It was recessed for victim impact and she's decided that she's not guaranteed.
All right. All right, the court is calling 2024 CR 3774 State versus Luis Alberto De Leon Jr. Can I have parties announced for the record for the state? Defense?
Jason Wolf for defense.
And are you Mr. DeLeon Jr.?
Yes, ma'am.
All right, everyone, just give me one moment, please. Sorry, Odyssey is extremely slow today. And now we have to put everything in Odyssey.
Why they named it Odyssey, Judge.
Yeah. All right, court is calling 2024 CR 3774 State versus Luis DeLeon. Can I have parties announced for the record for the state,
Kristen Muller, state your honor.
for the defense?
Jason Wolf for defense.
All right, and are you Mr. DeLeon?
Yes, Your Honor.
You entered a plea of no contest to indecency assault on February 25th, 2025. According to your plea bargain agreement, the state is recommending deferred adjudication. And at the last hearing, state you informed the court that you had spoken to the complainant,
Yes,
and the complainant has no objections to this agreement.
correct.
All right, is there anything you wish to say on behalf of your client?
No, Judge, we would just ask that you kindly follow the agreement. He's taking responsibility and we just want to put this behind him.
All right. And is there any reason why I should not consider jail time as a condition?
Judge, this was a fact pattern that both the defense and the state have gone back and forth on, quite frankly, during the plea bargain process. I know reading initially the police report as it's presented to the court has been reduced to an agreement of the parties that is a Class A through agreement and negotiation because of that fact pattern. We are here saying that this result is good for our client. He would like to take this result. And we just kindly ask that you follow that agreement. Assessing jail time, I think, would not be appropriate in this instance. And that's what we're asking. We just ask that you
Why
follow.
wouldn't it be appropriate? That's what I'm trying to get to the crux, because I read the fact pattern, the police report, and I'm trying to figure out why I shouldn't give him jail time as a condition. State, any response to that?
Sure, Judge. After speaking with the complainant and gathering more information, I think that this is more in line with what the state is able to prove, Judge. And probably more in line with what is appropriate in this case, Judge, as opposed to what it was indicted as. And we've explained that to our complainant and she fully understands that that's where we are.
So you don't think jail time as a condition would be appropriate in this case?
I don't, Judge.
All right. Are you employed?
Um,
What do you do?
I'm a district manager for ADT Security.
From what, for what?
ADT Security.
All right, does everybody think this is appropriate for him to be district manager of security and he's just agreed to do a permanent surrender of his TCO license?
I don't have any information about his current employment, Judge, or any opinion on his current employment.
All right, so what is, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Luis DeLeon.
All right, what specifically do you do?
I just train register sales, door-to-door sales.
All right, do you go into anyone's homes? Do you go door-to-door sales?
I just train. I train and run office meetings, make sure all the back office stuff's taken care of.
All right, this is what the court is going to order with regards to this occupation. If he is entering anyone's homes, knocking on any doors, he needs to let them know what his charges are. if that's what he's going to do.
Judge, may I address a couple of things?
Sure.
I'm hopeful that we're no longer considering jail time as a condition. I think he's granted deferred. Having jail time as a condition is a punishment that he certainly didn't anticipate. And I would hope that would not be something that would be somewhat busting our plea bargain.
Well,
We hate-
I don't think that's a busting of the plea bargain. I'm going to follow your agreement for him to have deferred. But if he is going to be employed, because it seems like he's given up his TCO license, but yet he's sort of still engaging in an occupation that's security. What I'm saying is, if he is not allowed to go into other people's homes as a director, unless he lets the person's home that he knows that he is entering, that he's on deferred for this. That's what I'm saying. He's not allowed to go into people's homes. You understand that, right?
Homes everywhere across this world. He's not allowed to go in there unless he
No,
expresses the conditions of this plea bargain.
If
That's
it's,
my
if it's,
understanding.
no, what I'm saying,
Even
you,
if
if
he's given
it's,
consent to enter
if
that
it's,
home?
if it is a part of his occupation, no, he's not allowed to.
During the course of his.
Okay, I misunderstood, Judge.
Okay. All right, so do you understand that? So if you, as a part of your occupation, go into someone's home and they're not aware of these charges and the courts finds out about it, there's going to be a motion to revoke filed. Do you understand? And you understand the reason why the court is requesting that? All right, do you have any children?
No.
What are their ages?
Daughter's 13 and my son's 10.
All right. So the court is going to sentence you to 2 years deferred adjudication. There's $1,000 fine that'll be probated. MRT, the AIDS awareness course. There's to be a permanent surrender of your TCO license. And it also says ID here. There's to be no contact with the complainant. There's to be no entry into any homes as a part of your occupation without notification of this charge. To the home's occupant and your employer.
Judge, do you want written acknowledgement or
Yes.
just verbal acknowledgement?
Written acknowledgement. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home healthcare provider or with minors, field visits 1 time per month for 3 months, 180 hours of community service restitution. I'm gonna require parenting classes. Once you completed parenting classes, your community service hours will be deemed satisfied. Probation, is there anything else? Is there anything else you need from the court in order to be successful on this probation?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. You're welcome.
Thank you, Judge.
You're welcome.
On the truth, I hear you. Good luck.
All right, just give me one moment. Ma'am, you can come around. Let me show you what's going on. I'm even looking over there. For some reason.
Be aware.
Okay. Well, all right, thank you.
Miss Eagle.
I don't know where that goes.
This is the best.
It is, you know what, and I did that whole thing where you're supposed to shut down the computer, I restarted everything. So now it's there. Who knew? All right, thank you. Just one moment. All right, court is calling 2023 CR 9068. State versus Jose Roberto Lopez. Can I have parties announced for the record for the state,
Megan Galloway and Andrew Edelman for the state.
for the defense?
Eric Sharp, Robert Porter for the defense.
And are you Mr. Lopez? You all need to move away from the side. Are you Mr. Lopez?
Yes, ma'am.
All right, state defense, yesterday we discussed the jury charge. Have both parties received copies of the charge?
Yes, Your Honor.
Defense has, Your Honor.
All right, any objections to the charge as presented? State,
No objections, Your Honor.
defense?
Yes, ma'am. We object to the inclusion of a self-defense instruction. I believe there's sufficient evidence to establish that.
You can remain seated, counsel. All right, so your objection is to no self-defense. Is that your only objection?
Yes, ma'am.
All right, state, do you have a response?
An instruction on waters with no evidence to support that the defendant acted in self-defense. The testimony that was elicited during this trial was that the complainant never even was able to strike or defend himself against the defendant because the defendant immobilized him so quickly. And so those facts do not give rise to an instruction for self-defense, Your Honor.
All right, and the court then will not include the self-defense instruction in the charge. Any other objections?
Nothing further for the defense, Your Honor.
All right, so each party, is 15 minutes enough time for closing? If it's not, tell me.
I would ask for at least 25, Judge.
I would agree, Judge. I probably won't use it all, but just to be safe.
All right, I'll give each party 20 minutes. Does anyone wish to have a time announcement?
2-minute warning.
The same, Your Honor.
All right, and as you all know, if I see that you're still in your argument, I always will give extra time. All right, the jurors are going to be lined up. Yes.
Judge,
Yes,
are we dispensing with the microphone?
you'll have to ask the court reporter. We have a new court reporter for today. They're going to stand probably towards here with the jurors. That will be fine still. All right, thank you.
Judge, so we're gonna reserve our time for rebuttal. In between, in the transition time, can I get set up then? Because,
Sure.
My drive, somebody's getting it.
Okay, no problem.
Thank you.
Oh, yeah, the defendant will need to say, you can appear by Zoom.
We've conferred and made an agreement with the state.
Yeah, but sometimes I don't follow those agreements. So, if you want, you can appear by Zoom.
Okay.
All right. Thank you. But your client will need to stay. All right, we're ready to,
And Laura,
I don't know what's
Laura,
happening with the mouse. Let me know when you have that ready.
Want to tell everybody about that. Yeah.
Okay. Oh, yes, she's not gonna tell them. Everyone, when the jury comes in, do not rise. While she's doing that, Mariscal, come forward. Jason, are you ready on Mariscal? It's the DWI.
Mr. Edelman,
Oh, yes, Judge.
All right, come forward. All right, you have high BRAC readings. Did you review the violation report with your attorney?
yes, ma'am.
All right, we're not on the record. Look, you're not allowed to drink alcohol
Yes.
while you're on this bond. Do you understand?
Yes, ma'am.
If you continue with what you're doing, what's going to end up happening is you're going to end up at the Bear County Jail because you're violating your bond. Do you understand?
Yes,
So when's the last time you had alcohol?
the 14th, February 14th.
All right, so why are you drinking?
It was, I did a surprise dinner for my wife at home and we had wine. And the next morning I had a soccer tournament. I did.
All right, here's the thing, not allowed.
Yes.
State, what are you requesting?
At the office.
And we're in agreement with that, Your Honor.
All right, this is what the court is going to do. There's going to be the alcohol awareness course. The court will ask that fees are waived. And there's going to be 120 sober meetings. In 120 days. And where are we on discovery? And I know this is his first time and you said there was a blood draw.
Yes.
All right, Ms. Ferguson, recall this in 45 days for discovery.
Change to March 25th date.
Yes.
Your defense counsel files a standing blood discovery. We approach the court to have that signed without.
Yes, that needs to be done today.
Okay.
But, will be April 21st. That week, you want me to do it for?
Do it the week before. All right, April 17th. Once you sign the reset form, you're excused.
Thank you, Your Honor.
All right, do not, if you feel as though you're going to drink alcohol, do not do it.
Yes,
Go to a sober meeting, you understand?
Yes, Your Honor.
All right, thank you. All right, you know what? If you have somebody who can who has a battery for this, because I think the battery's dead. So. Sure, sure. Let's see, Norma,
Yes, ma'am.
can you see if they can get a battery for this?
Yes. You know what?
I have no idea. All right, everyone needs to be seated. Take a seat. And you can bring the jurors in.
Not rise.
Jonathan. All right, ladies and gentlemen, you can see that our courtroom has more people in it than you've seen before. That is unrelated to this case. So it has nothing whatsoever to do with this case. Does everyone understand? It's just other people who are on the docket today. And sometimes we have people who will come in and they're just observing. So we are. So is the battery in this? No, it's not.
It didn't work. Judge.
Let me check on. Thank you. Just give me a moment. Our mouse has died. Ah, there it is. Okay, thank you. Thank you, Fashawn. All right, we're on the record in 2023 CR 9068 State versus Jose Roberto Lopez. I'm going to read to you what's called the charge of the court. It's the jury charge. You do not have to memorize it. You will have an original with you when you begin your deliberations. Members of the jury, the defendant, Jose Lopez, stands charged in count 1 of the indictment with the offense of aggravated robbery alleged to have been committed on or about the 8th day of May 2023 in Bexar County, Texas. The defendant, Jose Lopez, stands charged in count 2 of the indictment with the offense of aggravated assault alleged to have been committed on or about the 8th day of May 2023 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of robbery if, in the course of committing theft of property as defined below, and with intent to obtain or maintain control of property, he intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated robbery if the person commits a robbery as defined above and uses or exhibits a deadly weapon. 2, a person commits the offense of theft of property if he willfully appropriates property with intent to deprive the owner of property. It is no defense to prosecution under the law of theft of property that the actor has an interest in the property stolen if another person has the right of exclusive possession of the property. 3, our law provides that a person commits an assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault or causes serious bodily injury to another. 4, actor means a person whose criminal responsibility is an issue in a criminal action. Another means a person other than the actor. Appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent or the property is stolen and the actor appropriates the property knowing it was stolen by another. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether expressed or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by force, threat, or fraud, or given by a person the actor knows is not legally authorized to act for the owner. In the course of committing theft of property means conduct that occurs in an attempt to commit, during the commission, or in immediate flight after the attempt or commission of theft of property. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Possession means actual care, custody, control, or management. Property means tangible or intangible personal property or documents, including money that represents or embodies anything of value. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. All right, could I have parties approach? My question is for you all. If you all would like, I will give an instruction to him personally, or I will have him remain. But you all can ask that you go to an alternate. So that's something that you all can, I'll have you all step back, but you can think of that.
Instructor. Yeah. Instructor.
Instruct him?
Yes.
All right, thank you. All right. So juror, this is a very important matter. And what I can tell you is that in this matter, Mr. Lopez, the complainant, the attorneys want people to be actively listening and awake. If you think about it, if you are Mr. Lopez, or if you were the complainant, you would probably be upset that it appears that someone is sleeping during your jury trial. Do you understand, sir? Is that a yes? So, have you been awake? Do I need to start again with reading the jury charge?
Yes, ma'am. I
No, do you need me to start again?
no, ma'am.
All right, so you need to be focused because he wants you focused, the complainant wants you focused, and the attorneys want you focused. Do you understand? And throughout this trial, have you been sleeping or have you been awake?
I've been awake.
All right. And what is your juror number?
16.
All right. So state defense juror number 16 says that he has been awake throughout the trial. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss of impairment of the function of any bodily member or organ. Unlawful means criminal or tortious or both, and includes what would be criminal or tortious, but for a defense not amounting to justification or privilege. 5, a person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 6, you're instructed that under our law, voluntary intoxication does not constitute a defense to the commission of a crime. For the purpose of this law, intoxication means a disturbance of mental or physical capacity resulting from the voluntary introduction of any substance into the body. 7, protection of one's own property. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified under the law of protection of one's own property. A person unlawfully dispossessed of tangible, movable property by another is justified in using force against the other when and to the degree the actor reasonably believes the force is immediately necessary to recover the property if the actor uses the force immediately or in fresh pursuit after the disposition and the actor reasonably believes the other had no claim of right when he dispossessed the actor, or the other accomplished the dispossession by using fraud, threat, or fraud against the actor. I'm sorry, by using force, threat, or fraud against the actor. A person is justified in using deadly force against another to protect tangible, movable property. One, if he will be justified in using force against the other as described above. And two, when and to the degree he reasonably believes the deadly force is immediately necessary, A, to prevent the other's imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime, or B, to prevent the other who is fleeing immediately after committing burglary, robbery, aggravated robbery, or theft during the nighttime from escaping with the property. And three, he reasonably believes that the property cannot be recovered by any other means, or B, the use of force other than deadly force to recover the property would expose the actor to a substantial risk of death or serious bodily injury. Reasonable belief means a belief that would be held by any ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. You are instructed that the defendant is not required to prove the justification defense of protection of one's own property. The state has the burden to disprove the justification defense, meaning that the state must prove beyond a reasonable doubt that the defendant's conduct was not justified by the defense of protection of one's own property. 8, count 1, aggravated robbery. Now, if you find from the evidence beyond a reasonable doubt that on or about the 8th day of May, 2023 in Bexar County, Texas, the defendant, Jose Lopez, while in the course of committing theft of property and with intent to obtain or maintain control of said property, did use or exhibit a deadly weapon, namely a wooden object, a metal pipe, or a glass bottle, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Jose Lopez did intentionally, knowingly, or recklessly cause bodily injury to Abel Esquivel by striking Abel Esquivel with said deadly weapon, then you will next consider whether the defendant was justified under the law of protection of one's own property and proceed to paragraph 9. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, then you will find the defendant not guilty of the offense of aggravated robbery as charged in count 1 of the indictment. Skip paragraph 9 and proceed to paragraph 10. 9, count 1, justification defense of protection of one's own property. Keeping in mind the instructions on the law of protection of one's own property given in paragraph 7, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Jose Lopez, committed the offense of aggravated robbery as charged in count 1 of the indictment and as instructed in paragraph 8, you will next decide whether the state has proven beyond a reasonable doubt that the conduct of Jose Lopez was not justified under the law of protection of one's own property. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Jose Lopez, committed the offense of aggravated robbery as charged in count 1 of the indictment and as instructed in paragraph 8, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, Jose Lopez was justified under the law of protection of one's own property in that A, Jose Lopez was unlawfully dispossessed of tangible movable property by Abel Esquivel, and B, Jose Lopez reasonably believed the use of force was immediately necessary to recover the property, and C, Jose Lopez used the force immediately or in fresh pursuit after the dispossession, and D, Jose Lopez reasonably believed that Abel Esquivel had no claim of right when he dispossessed Jose Lopez of such property, or Abel Esquivel accomplished the dispossession of the property by using force, threat, or fraud against Jose Lopez, and E, Jose Lopez reasonably believed the use of deadly force was immediately necessary to prevent Abel Esquivel's immediate commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime, or Jose Lopez reasonably believed the use of deadly force was immediately necessary to prevent Abel Esquivel from fleeing immediately after committing burglary, robbery, aggravated robbery, or theft during the nighttime with the property, and F, Jose Lopez reasonably believed that the property could not be recovered by any other means or the use of force other than deadly force to recover the property would expose Jose Lopez to a substantial risk of death or serious bodily injury. Then you will find in favor of Jose Lopez justification defense of protection of one's own property as it applies in count one, and say by your verdict not guilty of the offense of aggravated robbery as charged in count one of the indictment. However, if you find from the evidence beyond a reasonable doubt that the defendant, Jose Lopez, committed the offense of aggravated robbery as charged in count one of the indictment and as instructed in paragraph 8, and you further find from the evidence beyond a reasonable doubt, A, Jose Lopez was not unlawfully dispossessed of tangible movable property by Abel Esquivel, or B, Jose Lopez did not reasonably believe the use of force was immediately necessary to recover the property, or C, Jose Lopez did not use the force immediately after the dispossession, and Jose Lopez did not use the force in fresh pursuit after the dispossession, or D, Jose Lopez did not reasonably believe that Abel Esquivel had no claim of right when he dispossessed Jose Lopez of such property, and Abel Esquivel did not accomplish the dispossession of the property by using force, threat, or fraud against Jose Lopez, or E, Jose Lopez did not reasonably believe the use of deadly force was immediately necessary to prevent Abel Esquivel's imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime, and Jose Lopez did not reasonably believe the use of deadly force was immediately necessary to prevent Abel Esquivel from fleeing immediately after committing burglary, robbery, aggravated robbery, or theft during the nighttime with the property, or F, Jose Lopez did not reasonably believe that the property could not be recovered by any other means, and Jose Lopez did not reasonably believe that the use of force other than deadly force to recover the property would expose Jose Lopez to a substantial risk of death or serious bodily injury, then you will find that the state has proven beyond a reasonable doubt that the defendant was not justified under the law of protection of one's own property under count one, and say by your verdict guilty of the offense of aggravated robbery as charged in count one of the indictment. 10, count two, aggravated assault. Now, if you find from the evidence beyond a reasonable doubt that on or about, just one moment. Aggravated assault. Now, if you find from the evidence beyond a reasonable doubt that on or about the 8th day of May, 2023 in Bexar County, Texas, the defendant, Jose Lopez, did intentionally, knowingly, or recklessly cause serious bodily injury to Abel Esquivel by striking Abel Esquivel with a wooden object, a metal pipe, or a glass bottle, then you will next consider whether the defendant was justified under the law of protection of one's own property and proceed to paragraph 11. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, then you will find the defendant not guilty of the offense of aggravated assault as charged in count 2 of the indictment. Skip paragraphs 11 and 12 and proceed to paragraph 13. 11, count 2, justification defense of protection of one's own property. Keeping in mind the instructions on the law of protection of one's own property given in paragraph 7, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Jose Lopez, committed the offense of aggravated assault as charged in count 2 of the indictment and as instructed in paragraph 10, you must next decide whether the state has proven beyond a reasonable doubt that the conduct of Jose Lopez was not justified under the law of protection of one's own property. Therefore, if you find from evidence beyond a reasonable doubt that the defendant, Jose Lopez, committed the offense of aggravated assault as charged in count 2 of the indictment and as instructed in paragraph 10, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, Jose Lopez was justified under the law of protection of one's own property in that A, Jose Lopez was unlawfully dispossessed of tangible movable property by Abel Esquivel, and B, Jose Lopez reasonably believed the use of force was immediately necessary to recover the property, and C, Jose Lopez used the force immediately or in fresh pursuit after the dispossession, and D, Jose Lopez reasonably believed that Abel Esquivel had no claim of right when he dispossessed Jose Lopez of such property, or Abel Esquivel accomplished the dispossession of the property by using force, threat, or fraud against Jose Lopez. And E, Jose Lopez reasonably believed the use of deadly force was immediately necessary to prevent Abel Esquivel's immediate commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime, or Jose Lopez reasonably believed the use of deadly force was immediately necessary to prevent Abel Esquivel from fleeing immediately after committing burglary, robbery, aggravated robbery, or theft during the nighttime with the property. And F, Jose Lopez reasonably believed that the property could not be recovered by any other means, or the use of force other than deadly force to recover the property would expose Jose Lopez to a substantial risk of death or serious bodily injury. Then you will find in favor of Jose Lopez's justification defense of protection of one's own property as it applies to count 2, and say by your verdict not guilty of the offense of aggravated assault as charged in count 2 of the indictment. However, if you find from the evidence beyond a reasonable doubt that the defendant, Jose Lopez, committed the offense of aggravated assault as charged in count 2 of the indictment and as instructed in paragraph 10, and you further find from the evidence beyond a reasonable doubt that A, Jose Lopez was not unlawfully dispossessed of tangible movable property by Abel Esquivel, or B, Jose Lopez did not reasonably believe the use of force was immediately necessary to recover the property, or C, Jose Lopez did not use the force immediately after the dispossession, and Jose Lopez did not use the force in fresh pursuit after the dispossession, or D, Jose Lopez did not reasonably believe that Abel Esquivel had no claim of right when he dispossessed Jose Lopez of such property, and Abel Esquivel did not accomplish the disposition of the property by using force, threat, or fraud against Jose Lopez. Or E, Jose Lopez did not reasonably believe the use of deadly force was immediately necessary to prevent Abel Esquivel's imminent commission of arson, burglary, robbery, aggravated robbery, or theft during the nighttime, or criminal mischief during the nighttime. And Jose Lopez did not reasonably believe the use of deadly force was immediately necessary prevent Abel Esquivel from fleeing immediately after committing burglary, robbery, aggravated robbery, or theft during the nighttime with the property. Or F, Jose Lopez did not reasonably believe that the property could not be recovered by any other means, and Jose Lopez did not reasonably believe that the use of force other than deadly force to recover the property would expose Jose Lopez to a substantial risk of death or serious bodily injury. Then you will find that the state has proven beyond a reasonable doubt that the defendant was not justified under the law of protection of one's own property under count 2, and say by your verdict guilty of the offense of aggravated assault as charged in count 2 of the indictment. 12, count 2, deadly weapon special issue. If you have found that the defendant committed the offense of aggravated assault as charged in count 2 of the indictment, and as instructed in paragraph 10, you are instructed to next determine whether the defendant used or exhibited a deadly weapon, namely a wooden object, a metal pipe, or a glass bottle during the commission of the offense of aggravated assault as charged in count 2 of the indictment. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Therefore, if you have found that the defendant committed the offense of aggravated assault as charged in count 2 of the indictment and as instructed in paragraph 10, and if you find from the evidence beyond a reasonable doubt that a deadly weapon, namely a wooden object, a metal pipe, or a glass bottle was used or exhibited during the commission of the offense in count 2, and that the defendant used or exhibited the deadly weapon, you will state in the attached verdict form. If you do not so find beyond a reasonable doubt that the defendant used or exhibited said deadly weapon, you will so state in the attached verdict form. 13, you are instructed that if there is any testimony before you in this case regarding the defendants having committed an act of misconduct other than the offense alleged against him in the indictment in this case, you cannot consider said testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such act of misconduct, if any were committed, and even then, you may only consider the same in determining the consciousness of guilt, if any, of the defendant in connection with the offense charged against him in the indictment, in this case, and for no other purpose. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging services on any social media platform, internet chat room, blog, or website, to include but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of trial or during the argument, if not supported by the evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view of reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence of his fellow jurors. Of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors, or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, Deputy Laura? The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by the presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any questions you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. So respectfully submitted, Judge Stephanie Boyd, 187th District Court. Suitable verdict forms are attached. Could I see parties before you begin closing arguments?
I would need some of the evidence, I think.
Okay, so this is what we do. All right, ladies and gentlemen, as you notice, we have a new court reporter. And for closing arguments, probably both the state and the defense are going to want to show evidence during their closing argument. So I'm just going to have you step in the hallway briefly. Do not begin your deliberations. I haven't given you permission to do that. And I'm going to let the court reporter grab the evidence. All right. All right, everyone, the juror, if you could have the jurors wait in the hallway, please. And we're going to have someone from the state and someone from the defense. If you'll go back with this court reporter to obtain the evidence, so she'll make sure it's the correct evidence.
Here, but would you like us to do that?
Oh, no, you can do it here. Okay, thank you.
I'm already with Lexi and Bob.
Okay, awesome. so much. All right, so y'all have all the evidence?
Yes, sir.
All right, and both parties, based upon what I've read, I'm gonna give each side 25 minutes.
Yeah, thanks.
All right, and,
Like bench mic because I'm not picking up everybody.
all right. And then we're gonna go back on the record briefly before the jury comes back in. And we're going on the record. I was unsure if the court reporter had picked up our conversations with regards to the juror that I thought was sleeping. My understanding from speaking to that juror and, oh, please proceed, in the presence of both parties, he was juror number 16. So was there, and I know both parties said they would like for me to give him instructions. So was there any objection to the instructions that was given by the court to that juror?
Not from the state.
Defense has no objection, Your Honor.
All right. Now, the next question I would like answered. We do have two alternates. If you all would like to remove him from the panel and go with the next alternate, let the court know.
Defense is fine with him staying on the panel.
We are as well, Your Honor.
All right, then, we'll start then. Let's bring the jurors in. Okay. Okay. No problem. Okay. All right, State, are you ready to proceed?
We are judged and we will reserve our time for rebuttal.
All right, defense.
Hey, please, court. Good morning, ladies and gentlemen of the jury. First off, I want to thank you for your service. Without y'all sitting here, the system doesn't work. All right. Let's talk about the case. What do we have that's uncontroversial? The bicycle. Mr. Lopez unequivocally never said that's not his bike. Okay. He identified that bike through a amateur weld job under the seat. Now, when you look at the charge, you will see that everything is in the perspective of Mr. Lopez. How did Mr. Lopez see everything? The bike saw it was his. Can someone deprive property from another? That's theft, okay? If I own the property, I own the property regardless who's in possession of it. And the law says I have the right to get that property back. Now, the interesting part about it, in Texas, you have that right when there's a number of offenses. They talk about it in the charge, burglary and some serious stuff. But they also say at nighttime. So that's the law in the state of Texas. You can get your property back by force at nighttime. That basically means if somebody's breaking into your car in the middle of the night, you can use force to stop that. During the day, it's a little different. At night, it's different. It's you can do it. Now, what is that? Not controverted. It happened at 4 a.m. in the morning. It's dark. at 4 a.m. So what do we got? We got a guy, fairly big guy, coming back from a bar on a bicycle that didn't belong to him. At the very least, he claims it was loaned to him by some guy named Joey. He's intoxicated. You heard him. He said, I got a buzz. Mr. Lopez sees him out there with his bike, identifies his bike, and says, hey man, that's my bike. I know it's my bike. So he approaches them, they start talking. I guarantee there was a confrontation. Esquivel was drunk. Maybe Lopez had a couple of beers in him. There was a fight. That's uncontroverted. There was a fight. You heard Esquivel say, yeah, we fought. There was a fight. There was a scuffle. All right. So how does Lopez say, hey, this is my bike? And I think Esquivel didn't dispute the fact it was his bike, right? He didn't dispute it. He just said, I got it from Joey. Well, here's the well job. Fight ensues over the bike. Mr. Lopez trying to get his property back. Nighttime. Esquivel's a big guy. He felt threatened. So what does he do? You heard the video. Somehow or another, a bottle's involved. You know, it's interesting. We've heard, and you look at the charge, it talks about a pipe. Anybody see a pipe in evidence? No. Bottle. Anybody see a bottle in evidence? Okay, good bottle. All right. No broken glass. You heard the CSI person talk about, no, there wasn't any broken glass. Beer bottles aren't exactly the most quality glass, and they break very easily. So you're thinking of somebody hitting somebody hard over the head with a beer bottle, there'd be broken glass. There wasn't. And of course, the infamous West Side trash. As I asked the detective up there, oh, pretty bloody scene. Yeah. See any blood on this? No. Okay. So what did the state do? They're reaching for straws. They got no clue what happened. So we said, we'll just pick A, B, and C and let the jury figure it out. Well, you know what they didn't figure out was there was 4. Mr. Lopez said he hit him with his fist. Nowhere in the indictment nor the charge this. Okay. So not my job to bring the charges to the court. That's the DA's job, the police department. The police department didn't do their job right. The DA didn't do their job right. That's not your problem either. If y'all believe that he hit him with his fist, and this caused the injury, you got to find him not guilty because fist ain't in here. You heard the testimony. Allegedly hit him over the back of the head with the bottle. But there's an issue with the eye. No mention was hitting him in the face with the instrument, whatever that was. So we got to look at the fact. Lopez says, I hit him with my fists. Where in the eye, maybe? That could have caused the damage. Now, you got to remember, when we talked about voir dire, we talked about being fair and impartial. And do not let sympathy play in your verse. Yeah. Esquivel's a sympathetic guy, big guy. He's got a vision problem because of this incident, but you can't hold that against Mr. Lopez because you got to look at the law, and the law set forth in this charge. One of the things you got to look at is, in order for them to establish that Esquivel had that exclusive possession of that property, all right? What does exclusive possession mean? It means him alone, no other person has claim to that property. And that's not true. The evidence is clearly shows that Lopez said it's his. Esquivel said, yeah, that used to belong to Lopez, but Joey gave it to me. Speaking of Joey, anybody hear what he had to say? He clammed up real quick, maybe because of the fact that, oh, shoot, I gave this bike away and I shouldn't have given this bike away. So let's talk about evidence. I didn't hear any medical people getting up there and saying exactly what caused the injury or how serious the injury was or anything like that. That's a burden of proof upon the state. They try to get it in with a detective. Of course, the detective's not a doctor, not a physician. He can to testify that. And the court realized that. All right. So let's talk about the offense. Aggravated robbery. They're saying Mr. Lopez stole his own property. According to Mr. Lopez, it was his property. Can you steal your own property? I don't believe so. So where does that leave us? You can't steal your own property. You can't rob your own property. That's step one to look at. Step two, if it's his property, he has the right to get it back. He has the right within his perception to use whatever force is necessary to get his property back. So one, it's his property, he can't steal his own property. Two, not guilty. Three, he uses his own force to get his property back. Okay, it's his property, not guilty. Let's talk about aggravated assault, second charge. Serious bodily injury with a wooden stick, glass bottle, or pipe. Pipe, glass bottle, no stick. And even if you were to stretch it enough, the evidence is clear that the glass bottle allegedly hit him in the back of the head, but didn't break clear bottle. All right. The damage to the face, no reference of that except fist. And fists ain't alleged in here. You got to follow the law. You got to follow the indictment. The way it's written is the state's got to prove beyond a reasonable doubt each and every element of the indictment. Okay? The indictment's a formal charge. The Constitution says each individual has the right to be formally charged specifically of what they've done and have the witnesses presented against them so they can be confronted. All right? Not one mention of fists. There's your reasonable doubt right there. Did the injury to the eye, was it caused by the fist? And additionally, we have the same issue with trauma. The eyes of Mr. Lopez, that's his bicycle. I'm going to get it back. There was an altercation. There was a fight. You can see that Esquivel was a lot bigger guy than Mr. Lopez. He was buzzed. People on alcohol have a tendency to be possibly aggressive. So, Lopez, looking through his own eyes, what do we have? We have, hey, that guy's on my bike. It's my bike. Never denied that. Sitting there with the detective back and forth. I don't know how many times he said, that's my bike. I know it's my bike. Well, how do you know it's your bike? I did a crappy weld job on the seat. Oh, but we don't have the bike, by the way, or the cell phone or anything else like that. So, one, evidentiary, Lopez says, my bike. This is what I believe, my bike. Okay? He's saying it's his bike. And the evidence says he was left with Joey. Where's Joey? He's not here. But anyway, never heard Lopez say, oh yeah, I gave Joey the right to give that bike to anybody he wanted. No, he said, no. I left it at the shop there a couple of months. We were going to do some work on it. And the next thing I know, I see this bike driving down the street with Abel on it. Okay? I go up to Abel and I say, Abel, That's my bike, buddy. Let me show you. Abel gets, you know, come on. And fight ensues. He gets his bike back. That to me sounds one, protection of own property, getting your own property back. Never was established it wasn't his property. And even if you look at there, they talk about, oh, well, if you can show that Esquivel had exclusive use of the property. Well, exclusive means no one else has got a claim to it. Okay? No one else has a claim to it. That's not true. Lopez says it's mine. I never gave it to anybody. There's the claim. So, based upon the evidence that we have, the only verdict I can see as aggravated robbery. Property. 2, aggravated robbery, serious bodily injury. They haven't proved 1, serious bodily injury, and 2, it means it's serious bodily injury. On top of that, Lopez wants his property back and is entitled to use whatever force is necessary to get his property back as he perceives necessary. Not what anybody else does, what he perceives was necessary at the time. So once again, I want to advise the jury that Plano, this isn't a game of I feel sorry for Mr. Esquivel. It's follow the law, follow the definitions, look at all the evidence, weigh all the evidence. That's what you're required to do. Thank you for your time, ladies and gentlemen.
He tried to deny it. That's what pissed me off. Ladies and gentlemen, this case was never about that defendant legally obtaining his property. It was about him taking to the streets and being a menace to society. And that is why we're here today. Now, I want to talk to you all about the law that applies in this case. We're going to look at count 1 first. And when you go back to the jury room, it's going to be labeled under subtitle 8, count 1, aggravated robbery. The state has proved all of the elements of this offense, and most of them are not in controversy. Okay, they're pretty much stipulated to a lot of the evidence. So the one that I have up there highlighted is, was the defendant in the course of committing a theft of property? And we're going to talk about that. But on or about May 8th, 2023, you all heard multiple witnesses testify to that date. Officer Reese, the victim, Abel Esquivel, and the detective. In Bexar County, you all heard those same witnesses testify that that address on San Felipe is located in Bexar County, Texas. It's uncontroverted that it's the defendant. You all saw his statement. It's uncontroverted that the defendant was acting with the intent to obtain and maintain control of that bicycle. It's uncontroverted that, well, we'll talk about the deadly weapon in a little bit. And the defendant did act intentionally, and he did cause bodily injury to Abel Esquivel. So let's talk about theft. The law says that a person commits a theft if he unlawfully appropriates property with the intent to deprive the owner of the property. And the appropriation becomes unlawful when it's without the effective consent of the owner of the property. So you all need to look at the facts and the evidence and determine who was the owner of that Schwinn bike on the day of the offense. An owner is defined in the jury charge that you have. Under Texas law, it is defined as the person that had possession of the property and who had the greater right to possession of the property. I submit to you all that Abel Esquivel had possession of the property for at least 2 months, and because of that, he had a greater right of possession than the defendant. The defendant was in the course of committing a theft. The law says, and this is in your jury charge, that it is no defense that the defendant has an interest in the bike, okay? Because Abel Esquivel had exclusive possession. The bike was given to him by Joey Lozano. And a fact that defense left out is that this defendant left that bike with Joey Lozano without any instructions or any date that he was going to return and get that bike. Now, count 2, aggravated assault causing serious bodily injury. These elements are not really in dispute. On or about May 8th in Bexar County, Texas, the defendant did intentionally cause serious bodily injury to anyone. Now, defense wants to submit to you that you didn't hear from a doctor. There was no medical professional that came in here and said that it's a serious bodily injury. You all have the definition of serious bodily injury. It's permanent disfigurement. My 3-year-old niece can come in here and tell you that being blind in one eye is permanent disfigurement. So that element is met. Now let's talk about the defenses that they have asserted in this case. Protection of one's property. Now I want to make it clear to you all, just because the court gave that instruction, it's not a comment on what the court thinks about the case, okay? The defendant is entitled to that instruction legally just because he's saying that the bike belonged to him, okay? And so let's look at the law. First, for you all to believe that the defendant was acting in protection of his own property, you would have to believe that he was unlawfully dispossessed of his property. That is not the case. He voluntarily gave the bike by his own statement. He went and left that bike with Joey Lozano at Jay's Party Rentals. That's not an unlawful dispossession. Even if you believe that he was unlawfully dispossessed of his property, his assertion that he was protecting his own property fails on all fronts. And why is that? To the degree he reasonably believes. And I want to talk to you all about this. In the jury charge, it's not exclusively from his point of view, okay? You need to think what a reasonable, prudent person would have done in the same circumstance. Was it immediately necessary? Was the force used immediately after the dispossession or in fresh pursuit after? And did Abel Esquivel obtain the property using force, threat, or fraud? I've already told you the defendant was not unlawfully dispossessed of his property, and he absolutely 100% was not justified in his actions. And why is that? Because the degree of force that he used exceeded what was necessary to get the bike back. Okay, he did not have to hit Abel that many times and permanently disfigure him to obtain possession back of that bike. 2, his belief was unreasonable. Now, I agree with defense that if you sit there and look at this case from the point of view of Malito, maybe Malito thought that that was reasonable, but any reasonable and prudent person would not think that those actions were justified. And it was not immediately necessary. Ladies and gentlemen, you heard testimony. That was not the first time that that defendant saw Abel Esquivel on that bike. The force was not used immediately or in fresh pursuit after the dispossession, and that's what we're talking about. Abel had had the bike for 2 months. And Abel Esquivel did not obtain the bike by force, threat, or fraud. It was given to him by Joey Lozano. And I think it's interesting, how things work out, because this morning when I was in the parking garage elevator, there was a beautiful gold bangle that was sitting on top of the button that you press. And so I assumed, oh, somebody must have lost that bangle. And I was like, well, you know what? That bangle surely is beautiful. And so I started thinking about the community that table over there wants us to live in. And what would that community look like? I'll tell you what it would look like. It would be Me taking that gold bangle, the owner being somewhere in the parking garage, seeing me with the bangle, me wearing the bangle to work for 2 months. And then one day, all of a sudden, the owner approaching me, assaulting me, causing me serious bodily injury to obtain that bangle back. That's not reasonable, and that's not a community that any of us want to live in. The defendant was not justified in using force to protect his own property, and he 100% was not justified in using deadly force. And there is no evidence that Abel Esquivel committed any of the crimes that were listed that would have justified the defendant in using deadly force. Okay. Abel Esquivel wasn't committing a fire. He wasn't entering into habitation without consent. He wasn't robbing or aggravated robbery anyone. He wasn't committing a theft at that time, and he wasn't causing damage to any property. Now let's talk about the testimony. During jury selection, I told you all that the evidence that you had received would be coming from that witness. Now, you all heard from Officer Reese. He was the first on scene. He observes the trail of blood leading from the defendant's mother's home to where the victim was found. He observes that wooden handle. He observes Abel Esquivel on his hands and knees bleeding profusely. He hears Abel's cries not to die. And he obtained the suspect location, the defendant's mother's home, and did research and found that the defendant was associated with that location. You all heard from Abel Esquivel. He testified that he received that bike from Joey Lozano. He had the bike for at least 2 months. That was not the first time that the defendant had seen Abel Esquivel on the bike. He testified that he was struck 3 to 4 times. He testified he's now blind from his left eye. And he also testified that he was threatened by that defendant for being a state's witness. And that goes to that defendant's consciousness of guilt. And that goes to show this had nothing to do with the defendant being a law-abiding citizen and trying to obtain his property back. Now, Detective Irvin, you all saw the interview that he conducted with the defendant. Okay, it's very, very telling. And Detective Irvin testified that in his training and experience, having knowledge of the defendant's assertion that the bike was his, it did not change his charging decision. In his training and experience, he still believed an aggravated robbery had occurred. Now let's look at the statements from the defendant. Okay, at first, he immediately distances himself from the scene and the crime. Okay, he says he was asleep at that time. He doesn't even know who Abel Esquivel is. But then later, he's able to give a whole lot of details about Abel, where he hangs out at the picnic, his girlfriend, and what he likes to do in his free time and where. The defendant also testified that he left that bike with Joey Lozano. He changes his story multiple times, but it's anywhere from 3 to 5 months prior to the offense. He testified that he hit the victim with a Corona bottle to obtain the bike. That right there, and I want to talk to you all about the deadly weapon allegation because defense brought it up. Whether it was State's Exhibit number 12, a metal pipe, or Corona, you all do not have to be unanimous on what you think the weapon that was used. Okay, 5 of you can say you think it was the bottle, 5 of you can say you think it was a metal pipe, but really all 12 of you should be saying it was the bottle because that came from the defendant's own mouth. So he's guilty of using that bottle in causing serious bodily injury, which makes that bottle a deadly weapon. Now, he also testified, you've heard a lot of, argument from defense. We don't have the bite. Where's the bottle? We talked about this in jury selection. The state takes their cases as they come. The defendant testified that he took possession of that bike and put it in his backyard, and then it mysteriously disappeared. He also testified that he took that bottle and threw it away because he didn't want to be charged with this crime. Also, he testified that he was in his mother's house watching.
think the term
Well, yeah, I'm sorry.
misstates the evidence.
All right,
I'll change.
all right, ladies and gentlemen of the jury, you're to disregard the prosecutor's last statement with regards to testifying. Does everyone understand? Any other instructions requested, defense? Are they, you may proceed.
Excuse me, he didn't testify, he didn't take the stand, okay, and we cannot take that and use that fact against him. What I'm referring to is his video statement, okay, and in his video statement, he stated that he was in his mother's house watching SAPD process the crime scene while Abel's being transported to the hospital. Now, if he was truly acting in defense of his own property, don't you think that would have been a good time for him to go out there and say, hey, this person took my bike and I was lawfully getting it back? But he doesn't do that. He waits until 5 months later in August when he's arrested, and the detective goes to interview him to make this assertion. And I will point out that it takes him 30 minutes to come up with that defense. The defendant in his statement acknowledges that he knew that Joey Lozano gave the bike to the victim. And he also testified that the victim did not hit him at all because the defendant immobilized him so quickly, the victim did not have a chance to even act in self-defense. And in the statement, the defendant also stated that the bike was not taken from him. Okay, those all go to annihilating his claim that he was acting in protection of one's own property. And one statement that he made was that the victim shouldn't have had his bike. Joey should have never given it to him. Well, maybe he should have told Joey, hey, don't give my bike out to anyone. There's no evidence that he told Joey what he could and could not do with the bike. The evidence is that he left it there and didn't return for 5 months. He also said, I would have let him keep it, but the laughing fucking pissed me off. That has nothing to do with him wanting to legally obtain his property. Now, right now, you're only deciding whether we met the elements or not. And I submit to you that we have met the elements on aggravated robbery and definitely aggravated assault causing serious bodily injury. As I stated earlier, just because the defendant had a property interest in the property is not a defense in this case, and we have proven our case beyond a reasonable doubt. There was some mention in the defendant's statement that he, was not in his right mind because he was intoxicated. That is not a legal defense. That does not negate his mental state or anything like that. I wish I would have killed him. Ladies and gentlemen, that is the most telling statement that came out of that defendant's mouth. He showed no remorse when he was told that Abel lost his eye. He didn't care. His response was that he wished that he would have killed Abel Escobar. Ladies and gentlemen, this defendant is guilty as charged in the indictment. Find him guilty. Abel's safety depends on it.
Thank you. Oh, can I have the chart?
We give two judges.
Ah, it is one of those days, isn't it? All right, if I could have defense and state here, please. All right, we'll see.
Just need to talk to him. It comes out.
You know,
But you can hang on to it.
oh no, we're good. We're good, but. All right, thank you. Oh, do you still have it? Okay. And what? Let me see. Oh, it is working now. Okay, thank you. I'm telling you, today is like Monday, right?
No.
For a long time. And I get to my office and I go, oh my God, I left my laptop bag. And then all the way back. I was like, gosh.
That's the worst.
Okay, yeah, let me.
Show off. I have Alex. Is he just bringing everybody up? I've already kicked her. Still need to approach. He's not out here, but I need to get him out here.
Vashawn,
Yes, Judge.
on the PSI, Luis Martinez, his attorney is, Luis Martinez, his attorney is in jury trial, so that's gonna be recalled for March 20th. Family violence. Luis Martinez is gonna be recalled for March 20th. His attorney is in jury trial. All right, who's here on Gilbert Salinas? Where's your client?
He's in the back.
All right, everyone. Excuse me, attorneys, just form one line. Thank you.
It's a long line.
I know.
Stand right there. If you're saying that you speak up, yes, no, there's no ma'am, okay?
Hello. Hi. So on this case, where are we on discovery?
There have been some videos uploaded, and I believe I need to bring a USB drive to get some other documents that I have been notified of that are too large for them to upload, Judge.
All right. And is there going to be a need for any type of evaluation with your client?
No,
All right. All right.
I don't
Miss-
believe so.
Okay. All right, Ms. Ferguson, I need a 30-day reset on Gilbert Salinas.
I'm gonna dismiss it. I just need to find some dismissal claims.
Thank you. All right, we're going to come back on April 7th. Once you sign the reset form, you'll be excused. Thank you for dressing appropriately for court.
Thank you.
All right, so just have a seat and your attorney will bring the reset form to you.
Thank you.
You're welcome.
You're right, Judge.
No, it's discovery.
I always say that. I like to see properties.
No. Yes. Where's defense counsel? Norma, could you have Robert Porter or either Gary Chirek come back, please?
I'm working on that right now.
Jeremiah Miller. Who's the attorney for Jeremiah Miller? Good morning, Judge. Good morning. So, on this case, it's plea deadline date. Do y'all want a jury trial or you all reach an agreement?
Your Honor, we are still confirmed, I understand in court, like, to send it for jury trial and something for that. But. the defense counsel has now, and I are still confirmed.
Well, if you all got to reach an agreement, it needs to be done today because after today, the court will not consider any plea bargain agreements. This has been going on since October. So if y'all going to reach an agreement, it needs to be done today. If it's not going to be done today, then the court will not accept any plea bargain agreements without good cause. Otherwise, you have to plea open to the court.
At this stage, maybe we should just send it for jury trial.
Yes, Judge. All right. How long do you expect this trial to last?
I think we can get it done in a day, Judge.
All right. Let me see. All right. March 18th.
Yes.
Thank you, Judge.
Once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome.
Mr. Porter, or Gary Trax,
All right, so Norma, this case, Miller is set for jury trial on March 18th.
The plastic bag. They're doing border the murder. It's like. For Isaiah Gibson, please. Thank you.
Are you ready on it?
No, I need to ask for a reset. It's not bad. Okay. Oh. Oh, no.
Angel Palencia. You need to be on the second row. Joseph Grant. All right, just have a seat. Abel Favala. Yes.
Judge, good morning.
Hello, good morning. So did you get a chance to confer with the state?
I did, Your Honor. We would like to proceed forward with the restitution hearing.
All right, are you all prepared for the restitution hearing? All right. All right, so you say you don't believe, do you know for sure you're not ready for a restitution hearing?
See.
All right, probation. On Abel Favala, have you received any updates on restitution from the complainant?
Yeah, he's downstairs. Judge, Fafala is a drug court.
Okay,
They study our systems are not the same,
okay.
so it'll take me a little bit.
All right, so just have a seat. They're gonna see if they have anything.
Your Honor, sounds good. And then once that information is ready, maybe we approach. that.
Yes.
Thank you.
No, he's.
All right, who's here on Isaiah Gibson? And where's Mr. Gibson?
He's in custody, Judge.
Okay, once they bring him out.
Can I at least ask you, make the court aware of what I'm asking for?
Sure.
He is appointed to my boss, my dad. He is his appointed client.
Mhm.
My dad's currently on an airplane right now. He thought he meant to come by and get this reset before then. So we're just asking the court for a reset on this matter.
Okay, all right, once he comes out, we'll take care of it.
All right, thank you, Judge.
You're welcome.
Yes. They can turn the bottom.
Yeah, as soon as he comes out, we'll just need the interpreter and then I can let the judge know
And
what's
Deputy
happening.
Laura, I don't know if he's been requested, but we need Isaiah Gibson. Yes, yes.
Referred over to corrupting.
All right, can I see the file on Anthony Eduardo Marino, please?
I need you to set it in here.
Judge.
Or if I need you to tell me, I need to go call them, tell them. You want to move their butts down there, I'll do that too.
All right, I'm sure you'll let your client know.
I'll let him know when he's brought out. Yes, thank
All
you,
right,
Judge.
thank you. Thank you so much for volunteering to step in.
Of course, anytime. Thank you.
I'll back them up. They're in here. Okay.
One of my intake cases.
Okay. Oh, what's the offense?
Oh, did I not write it on there?
They're bringing them up. I'm gonna get.
Because you know, they're
Bring it back
looking
later.
at everything I sign. All right.
What is radar?
You. Trey,
So if you have. And also. Bond corrections,
Yes.
Send those to Robert. Okay, so you'll set those, the ones I gave you. Huh? That's fine, yeah. Okay, perfect, thank you. How are you? I need to drop. Yeah, state. Gave me this information, I got you. It's information.
Just writing in here, oh, you wanted to.
Or no, problem. Thank you, Norma.
Just as I was taking my first bite.
yes, no. So anyway, I wanted, before the evidence is sent back with the jurors, I wanted you all to confer to make sure.
We did before when she brought it out, so.
Well, no, I mean, because it's going back.
Okay, yeah.
So,
Yeah.
okay, all right, thank you. Okay, all right, thanks. And I'm so sorry, what's your name? Vita? All right, thank you. All right. The person who's on Jerry Castillo, did you confer with the state?
Yes, sir.
All right, Jerry Castillo?
May I approach, sir?
Yes, where's your client?
He is in the hallway, Your Honor. You're going to be asking to withdraw that motion today. There was some new information that we were made aware of, that I need to kind of investigate a little bit
Right.
before proceeding to a hearing.
All right, so, I mean, he's on the docket, so he needs to be in.
Oh, you want to,
Yes.
okay.
All right, we're going on the record. And 2022 Council, you're on this side.
Yes, sir.
2022 CR 10840 State versus Jerry Castillo. Could I have parties announced for the record?
To the state of Texas.
Peter Calderola for Mr. Castillo, Your Honor.
And you're Mr. Castillo?
Yes, Your Honor.
All right, so your attorney had filed a motion asking that the bond conditions be amended or altered, and counsel, are you withdrawing that motion?
That's correct, Judge.
All right, then the motion will be withdrawn for the record. We're off the record. Listen, based upon what you're charged with, you're gonna have to be on GPS. You're gonna have to pay for it. You understand?
Yes, ma'am.
All right. Is there anything else from either side? All right, thank you. Thank you for dressing appropriately for court.
Always for you.
All right, thank you.
Thank you, Judge.
Thank you.
Have you excused?
Yes, you may be excused. Renee, do you have an update? Yes.
This is with regard to Mr. Favela, Judge. I know that felony drug court, we're still waiting to hear back. I believe they were not able to get in direct contact at this moment. And I think the state would need to try to attempt to fill in their possible witness, Judge. So we're unopposed for a reset, maybe 2-3 weeks. I know.
All right, let's have your client come up.
Mr. Favela.
Hi. So, Mr. Favala, counsel, if you would like for him to appear by Zoom, if he's able to appear by Zoom, since this is a restitution hearing. And what I'll do, this will be the last setting state that the court is going to allow for restitution. So March 20th, is that a good date for everyone?
Is that at a, what
It's
date?
Thursday.
Okay, because you usually have family drug court on Thursday. We could do either a Monday or Tuesday, Judge, because Thursday.
All right. So Tuesday, the 18th.
Yes, sir, that will work with us.
So once you sign the reset form, you're excused. And thank you for dressing appropriately for court. Yes. All right, everyone, you're in a courtroom, whisper. Do you have any objection to their witness
No
appearing?
objection, Your Honor.
All right, yes. So how's everything going in drug court?
Pretty good. I'm just trying to get my affairs in order and keep up with it.
All right, well, you're looking better.
Thank you.
All right, if there are any issues, let me know, but drug court is a good program.
Yes, ma'am.
All right, so just have a seat. Your attorney will bring the reset form and I'll notate that you can appear by Zoom. That way you won't have to travel back downtown.
Thank you very much.
You're welcome.
Thank you, Your Honor.
You have a good day.
Oh, thank you, you too. Vashan Favala is gonna be recalled for March 18th. And all parties are gonna be allowed to appear by Zoom. Norma Favala, March 18th.
She told me to. Go ahead. Jubber.
No, I don't have an Aguilar file up here. All right, Isaiah Gibson. Has he been brought out? Come forward, Trey. All right. So I hope he's enjoying his travel and getting Rachel in her new place.
I believe so, Judge.
She is living a great life.
She is. Yeah.
Want to be young and free again,
Yep.
right? So when will he be back?
He'll be back next week, Your Honor. I know he's out of county on Tuesday, but any day other than that, we will be ready to get this matter resolved.
All right. Ms. Ferguson, on this, we're not going to be able to do it next week because I'm allowing attorneys for the state and defense attorneys to be off for spring break because everybody has a young child. And as I say, this will be the only time in 2025 that you can do spring break with your
Right.
child. Then it's going to be a new year. All right, so we can bring it back the week of the 17th. So it's the 17th, the 18th, or 20th.
Let me confirm real quick.
Yeah, no, okay.
The 20th is fine, Your Honor.
All right, Norma, if you'll put this on March 20th, it is Gibson. All right, and we'll let him know when he's brought out.
Perfect. Thank you, Judge.
You're welcome.
Have a good day.
You too. Deputy Lord, you just let him know his attorney is out of state. All right, just give me a moment. All right, who is here on Daniel Munoz? Thank you. And if you have him come down. All right, so on this case, I think what we were waiting on is the immigration attorney that was requested and the sanity eval.
Also the psych eval, yes.
So where are we on those things?
That has not been done yet. I filed a motion a while back and then I emailed some of the collateral information that I had for whatever doctor evaluates him, but I don't think that's been done.
All
He says
right.
the doctor hasn't come to meet with him yet.
All right, Norma, if you can make sure that magistrate's court.
Can you sign that motion again, Judge?
No, I've already signed it. It's here and it's signed. So I don't understand where the breakdown in communication is. This has been signed since February 4th. So I don't understand.
Give it to you, IRA.
All right, thank you. All right, and where are we on MAC?
They were actually here to meet with him today, earlier today, so I think they're gonna meet with him here in court.
All right, then what I'm gonna do is I'm going to recall this case. I'm gonna set you for May 1st. I'm hoping by then the evaluation will be done. Everything will be done with immigration. If for some reason it's done sooner, your attorney can have you placed on the docket sooner. This is just the length of time it takes for things to get done. Are you okay with May 1st, counsel?
Yes, that should work for me, Judge. No problem.
All right, is there anything else from either side?
Okay. No.
Thank you. All right, thank you.
It's been given to you, IRA.
Maybe excuse your.
My understanding, you have someone else. I don't know who that is, but we're gonna find out. Norma, on Munoz, recall that for May 5th?
Judge, I'm sorry, may I approach briefly?
Yes.
Gonna go straight through, because I need the interpreter, but I haven't done paperwork yet, so I just wanted to,
You better get with the interpreter and to have her do the paperwork, let her know.
so go ahead and go do now. Okay.
Yes. Okay, all right. You can go ahead and order it now. Okay. Oh, and Norma, let me put something on for me.
No estoy hablando.
Oh, Deputy Laura, what does that mean? Oh, nobody talking. It
sound the same sometimes.
Yes.
No, it's the, you know, you can do the nuggets, but tell them you just want it grilled without the bread. Alexander Aguilar. That's already done.
Oh, I thought you wanted.
Oh, Alvarado. I'm sorry, just to the side, 1 second. All right. Are you able to understand me? Can you-
¿Necesita intérprete en español?
Just 1 moment.
You can have a seat for just a moment, and then once they're done, then you can come back up. Thank you.
You should just told us.
Oh, we don't need Megan. We're good. All right, so your case was dismissed. The state is saying it's because of insufficient evidence. Do you understand?
Okay, see.
Okay, yes.
Do you have any questions?
No.
No.
All right, how do you say okay in Spanish? What? That's how you say okay in Spanish? In French is d'accord.
K.
All right, so we did the K. All right, I need to put an accent on things. All right, good luck to you.
Muchas gracias.
Thank you
De
very much.
nada. Thank you. All right, Alexander Aguilar.
We're ready on Mr. Marvin. Signature.
Yes, 1 moment. I'm sorry. Odyssey is playing games right now. It's, you know, the little, I tell you, if you don't have patience, this will teach you patience. You know, Will Ferrell said, before you get in a relationship, you need to see how somebody behaves when the computer is not working. Okay, you say that and you laugh as though you should have done that.
Yeah.
Like you should have.
A lot of things I should.
All right, on this case, discovery, where are we?
Still waiting. I just got hired last week, Your Honor.
Okay.
From what I understand, we've been waiting on DNA for quite some time.
All right, where are we on DNA? And I know it hasn't been that long. We've been waiting on DNA since February. And I did sign the protective order for the CPS records. So you have the CPS records?
I'm still reviewing. We just got everything into our office, I think, Wednesday, and I'm still reviewing it. I'm not positive,
Okay.
but I can get you an answer on that.
Probably follow up on the results and make sure this is what it is. Thanks, Council.
All right, Norma, on this case, recall it for discovery May 1st. That's going to be the last of discovery. If for some reason the DNA results are not in, I'm going to need to know why they're not in. All right. Anything else?
Nothing.
All right. We will see you back on May 1st.
Thank you.
Thank you. Ms. Ferguson, that is Aguilar. What page is Aguilar on? All right, thank you.
En español, todo derecho.
And then what page is Munoz on? Daniel Munoz?
Todo derecho.
All right, thank you. Who's here on Jacob Kawazawi? All right, come down. All right, let me see what is happening with this case. All right, discovery, ballistics, GSR.
And I know that the lab results on the ballistics firearms have come back. GSR should have come back. I haven't seen it.
Okay.
But GSR shouldn't be that far behind if it's already been done. It should have been done.
All right, so I'm gonna give you all one final discovery setting. Norma, put this for discovery the week of April 14th. That's tax season for solo practitioners. That's really a bad time for solo practitioners. I've been there where you're just like, this is wrong.
I'm out of town the 14th and the 15th. So
Right, so
16th,
17th.
17th, 18th,
Look at him,
17th.
he's traveling during tax season. He already has it all together. That's good.
May I apologize, Judge, but I'm taking my son to see ACDC.
Oh, ACDC?
That was his Christmas present.
Oh, it's gonna be awesome. All right, so the 17th,
Yes, Your
you
Honor.
have to make sure he gets some swag from there.
A little something, yes.
Yeah, I like ACDC.
I thought it was one that he had to see.
Yeah, that is, you know, I love it when fathers spend time with their children because, especially the boys and the girls, because pretty soon they're gonna be grown. And this is something they can share with their
Senior
children.
in high school, he just got into A&M, so we're pretty proud of him. Yeah, I'll have 3 at A&M next year.
Oh, wow. Talk to Jason about that. So LSU just wasn't even in the radar. That just breaks my heart.
And we're not an Aggie family, but one daughter went, so I can. I said, okay.
All right, you know what? I'm putting y'all to jury trial right now. Okay, all right, so you're gonna come back on April 17th. This is to make sure that everybody has all their discovery. I'm giving your attorney a chance to review that. And then after that, state on that day, will you be prepared to make a offer?
Yes, sir.
All right, so the state will present an offer on that day, then your next setting is gonna be a plea deadline date. And if you're not able to work things out, then the next setting will be a jury trial. Do you understand?
Yes, Your Honor. Yes, Your Honor.
Yes, Your Honor.
All right, thank you.
May
All
we
right,
be
here's-
excused?
Yes.
Please have a seat, sir.
Okay. All right, who's here on Sauceda? Is there an application?
It's Rick Fergus, ma'am.
All right, probation, this is an application.
Yes, sir. I got it.
Court is calling 2024 CR 009-826 State versus Giselle Marie Sauceda. Can I have parties announced for the record?
That takes care of him, the state law.
Hector Gonzalez for the defense.
Okay, I cannot see over there. All right, counsel, have you received all discovery?
Yes, ma'am, we have.
And did you review it with your client?
Yes, ma'am.
And you're Ms. Sauceda? Did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney? Did you understand it?
Yes.
All right. Court will find that the state is in compliance with discovery. Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do. Judge.
State, are you proceeding on the indictment as presented?
However, when less than included possessions.
Any objections?
No objections.
All right, are you chewing gum?
Yes.
Not allowed. That's okay.
Thank you.
All right, any objections to the state proceeding on the lesser included offense?
No, ma'am.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
All right, did you understand your charge? Well, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 2, 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Saucedo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yeah.
Are you a U.S. citizen?
Yeah.
Court will find that defendant has knowingly and voluntarily waived the right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 2, the lesser included offense of possession of a controlled substance, penalty group 2, 1 to 4 grams. There's a $2,000 fine. State recommends deferred adjudication, and there's to be restitution for drug testing. Did you understand that to be your plea? Defense?
Yes, ma'am.
You're gonna have to speak up. Did you understand that to be your plea?
Yes, ma'am.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand? I'm sorry, did you understand by signing that paragraph, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, there be any such motions?
No, ma'am.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state? The court does not have to follow those recommendations.
Yes.
Then to the offense in count 2, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No.
Sorry, what?
No contest.
State any evidence.
Yes, Your Honor. State Exhibit number 1 called.
No objections.
All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Do you wish to proceed with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
No, ma'am. Other than she has no priors.
Oh, sure, I will. Thank you. Sorry about that. All right, who is Olivia Bias?
My grandma.
Your grandmother? Okay. Was she in vehicle at all?
Yeah, she, when they were towing my truck, she got there like right after.
Okay. All right, who do you live with?
It's, my girlfriend and my daughter.
All right, just if you could step back for a moment.
Do you need the defendant out here?
Just 1 second.
So it's still the same regardless of whether.
Mario Quintanilla. He's up here.
All right, the parties on the jury trial, could I see y'all just for a moment?
Lozano.
We,
Lozano. Oh, we have him in the back.
oh, no, I won't need your client.
I don't know where Gary is.
All right, let me just tell you the note I received. No, not yet. All right, so if you all can come back up on Saucedo, please. Telling you today, the computer systems were just not working. All right, we're back on the record in 2024 CR 009-826. Are you employed?
Yeah.
What do you do?
I work at Amazon in the warehouse.
Okay. I will tell you, when they do the Amazons and they say you're going to get next day service, that's a lot of pressure for the employees. I'm just throwing that out there.
They're pretty accurate too.
Oh, yeah. All right. So if you're drug tested today, what are the results going to be?
Thank you. That's,
So-
and then I would come under.
All right, so here's the thing. This is why I tell everybody, I'm going to grant your application, but I'm trying to make sure that I give you conditions so that you can be successful on it. So if you're not going to be negative, now's the time to tell me, because they're going to drug test you.
They can, I'll be negative.
Okay. All right.
They'll do random tests and you get tested right before you get hired.
Okay. All right. So they're going to test you regularly at probation as well. Do you understand?
Yes.
Do you have any children?
One,
Age?
or gonna be 5.
Okay. And live with you?
Yeah.
All right, probation, this is what I'm gonna do. I'm gonna sentence her to 3 years deferred adjudication. There's a $2,000 fine that will be probated. Proof of employment within 30 days. No employment as a home health care provider or with minors. There's to be regular random UAs. Regular reporting by Zoom or in person. 200 hours of community service restitution. Once she completes parenting classes, that will be deemed satisfied. Field visits 1 time per month for 3 months. Restitution, if any, to SAPD for drug testing. And there'll be a TAP evaluation completed out of custody. Follow all TAP recommendations with this exception. If TAP is recommending inpatient treatment, we'll start with intensive outpatient treatment. Probation, is there anything else? Is there anything else you need from the court in order to be successful? Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you.
Thanks.
You're
Thank you,
welcome.
Judge. Appreciate
Thank you.
Have a good day.
You
Judge,
too.
may I approach?
Yes.
Mr. Porter already looked at it.
All right, so
Same problem.
yes, you all need to do it on the computer. And the reason why I say do it on the computer Jose Mejia.
Page numbers 34.
All right, just send it to me.
He was on page number 4 of your docket, Judge.
All right. Oh, thank you so much. All right, so you're asking for a bond reduction?
Yes, Judge, we had filed back in November. And I think that originally it was going to go to the other court, but now that we're here, Your Honor's been nice enough to consider it today, so we're asking the court to consider it today.
All right, are you ready to proceed?
Sure.
All right, court is calling 2000, I think, 2002?
Yes.
Yes, judges.
All right, court is calling 2002 CR 8385 and 2002 CR 8384 and 2002 CR 8386, State versus Jose Mejia. Can I have parties announce for the record for the state?
Jason Jarrett, Your Honor.
Defense?
Charles Bunk for Mr. Mejia.
All right, and are you Mr. Mejia? And how long has your client been in custody?
Since May, he's been here since May the 9th of 2024.
All right, so,
He spent a little time in another county before he was brought here.
all right. So the defense has filed motions to reduce bond in each of its cause numbers. State, did you have a chance to review the motion to reduce bond?
I've spoken with Mr. Buck about it, but I have not looked at them. So I imagine that they're just asking for a reduction.
All right, were you all able to confer and see if you could reach agreement?
Judge, no, we're not in agreement.
We conferred, we were not able to reach an agreement.
All right, so, and the cause number ending 84. The bond is currently set at $10,000.
We'll waive our request in 8-4 just to expedite the process.
Okay. Any objection to the waiver? And then, and the cause number ending in 85, the bond is set at $100,000. And the cause number ending in 86, the bond is set at $250,000. And 85, he's charged with attempted murder. And in 86, he's charged with murder. All right, defense, it's your motion.
I'll call my client for the purpose of this hearing.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you're gonna need to speak up so I can hear
Yes, ma'am.
and so the court reporter can hear. You can lower your hand. State your name for the record.
Jose Mejia.
All right, defense.
Mr. Mejia, you're the same Jose Mejia that's charged in those two indictments, is that correct?
Yes.
And you have been here in the Bexar County Jail since May the 9th of 2024, is that correct?
Yes.
And on these two bonds, the first bond for the attempted murder is set at $100,000, correct?
Yeah.
And the
Yes.
second bond is set for the murder offense is set at $250,000, correct? Now, I know you have family present in the courtroom, am I correct? in
Yes,
that?
sir.
And can you tell the court which members of your family are present today?
It's my mom, my aunt, and my brother-in-law.
Okay, and if those members of your family attempted to raise the funds necessary to make the bonds that are set at the current amount, have they tried to make your bond?
They tried, but it's like,
Have they been able to?
no, they haven't, my mom don't work, she gets, then she has my niece, she's taking care of my niece.
Now, you yourself, sir, do you have the money yourself to make these bonds?
No.
Okay. Do you own any bank accounts?
No.
Do you own any automobiles?
No.
Do you own any property?
No.
Now, you understand the court, if she considers reducing your bonds, she could put you on devices such as the GPS monitor. Do you understand that?
Yeah, they told me.
Okay. And you certainly would be willing to comply with any conditions of bond she would give you,
Yeah,
correct?
in the condition,
And would you live, or if you were released on a reduced bond, where would you be planning on living
with my mom,
with your mother? And does she live here in San
in
Antonio?
San Antonio.
Okay. For the purposes of this hearing, Judge, that's all I have.
All right, just a moment.
I'm sorry.
I think there's no paper in the printer because I only got 12. Thank you.
There's some paper in the front. I just put a new green. I put a brand new green. in the-
Well, I only got 12 pages. All right.
That's all the questions I have for the purposes of this hearing, Judge.
All right, any questions, state?
Yes, Your Honor. Mr. Mejia, this case is from 2002, allegedly the murder, the attempted murder and the degree to the child. Is that correct?
Yes,
Where have you been since 2002?
I was in Mexico, I got a wife and a kid over there.
And you had a wife and a kid there previous to 2002?
Yeah, no, after,
After 2002?
yeah,
So from 2002 to the present, other than the time that you've been spent here in Bexar County or in the other
Yeah.
county, you've been in Mexico for the last roughly 22 years?
yeah, years ago, been working and having my family.
So you have a family and.
Oh, I had a job, I
and everything
had a
down
job,
In Mexico?
yeah.
Okay. No further questions, John.
All right, any other questions?
Now, Mr. Mejia, you didn't know that you had these warrants to do until you were arrested, correct?
Yeah, I turned myself in,
Right,
like,
once you found
yeah,
out.
because they,
That's all I have, Judge.
Your Honor, just
Yes.
one other question. You said you turned yourself in Mexico?
yeah, like, I told them I was American because they wanted to lock me up. They kidnapped me from a car with my son. They took me away from a taxi car,
And you're aware, who kidnapped you from?
the cops,
The cops,
yeah,
the Mexican,
yeah,
and then they turned you over to.
no, they didn't turn me in. I told them I was American. They didn't turn me in. I volunteered to,
What, are you aware of why they picked you up from that vehicle?
no, they never told me nothing. They never told my mom nothing. They never told my wife nothing. They just got me and left my son in the taxi.
You're not aware if they are aware that you had warrants out for this murder and attempted murder and injury to a child?
No, because if they knew, like, I had a job and everything, they never arrested me. I've been arrested over there. And they never sent me over here, you know what I mean?
Well, I guess my other question is, you're not aware of a task force that was formed at of recent time in the last year that was gaining people that had, or detaining people in Mexico that had warrants out for murder and attempted murder, but the American side and the Mexican officials have.
I didn't know none of that.
Not aware of that.
No, I wasn't aware.
Thank you. No further question.
All right, any further questions?
That's all I have, Judge.
All right. The court will hear argument and just off the record for a moment. Edelman? All right, thank you so much. All right, we're back on the record. Yes, I'll hear argument.
Just on behalf of Mr. Mejia, Judge, we're asking the court to consider he's testified he does not have the money available to make the bonds. We're asking the court to consider the reduction of the bond, the 250, we're asking the court to reduce that $250,000 bond to a bond to consider reduction in the amount of $125,000. The $100,000 bond, we're asking the court to consider reducing the amount of $50,000. We're certainly understanding the court will place Mr. Mejia on GPS full house arrest, and we're certainly okay with that. He has a residence here in San Antonio to live with his mother, who is present in the courtroom. He's been present in every setting. The monitor gives the court the guarantee that he will continue to come to court. As he testified, he did not know, yes, he was in Mexico, but that's not because he did not have these charges and flee the country. It's not a situation where he was on bond and left. That would put the court in a completely different perspective, I believe. So having no evidence that he knew of the charges before he left, I certainly think the court could consider this reduction as a reasonable request. He has been in jail since May 9th of 2024. We don't think the request is unreasonable. We're asking the court to consider the reductions and grants the defense request for bond reductions in 2002, 8385 and 2002, 8386.
Judge State's position is, for one, I think aware of the murder, attempted murder, and the child that happened. That's like in Wisconsin, Carolyn's been there for the last 2 years. So when that argument is a fight, and also there's the actual charges, the several charges, the state would be in a position that it's a state of the community.
All right. In each motion, the court is going to deny your application for reduction. The court will include full GPS. If released, waive all fees as it relates to GPS. And counsel, if he is released and there's an issue, because sometimes there's an issue where GPS thinks there should be a payment, just let the court know and I'll make sure that's done.
Yes, Judge.
All right.
Do we need to address the next setting for the court?
Yes.
While we're here?
All right. So with regards to each of these cases, counsel, do you know if you have discovery?
Yes, Mr. Garahan has been able to get the discovery uploaded through the various formats that were antiquated at the time, or antiquated now, present at the time. I believe I have everything that they have.
All right. And so what I will do, State, were you able to tender an offer or no?
No, not today, Your Honor. Mr. Buck asked for an offer today, but I was not prepared to take an offer today.
All right. So what I'll do is I will reset this so the state can tender an offer. What is a good date for you, counsel?
What time frame are you looking at, Judge?
I'm thinking in April.
Okay. Sometime end of April, somewhere in there?
Well, it would have to be April the 28th.
April the 28th, okay.
As you know, my mom's birthday is before that.
Yes, so the 28th is good, Judge.
All right, Ms. Ferguson.
Is that Fiesta?
Oh.
Yes. That is Fiesta.
I don't want to ruin their fiesta.
Understood.
So I can put it May 1st.
That's fine.
All right, Deputy Laura, May 1st, because I understand fiesta is over. Yes. In the month, am I right? In the month of May? Oh, look at Raymond shaking his head. Okay, so he just throwing, okay. All right, so we're going to be back then on May 5th.
May 5th.
Cinco de Mayo.
Okay.
All right. Yes, it's for discovery and for the state to tender an offer, but just have an acknowledgement of discovery right on that day. All right, is there anything else?
No, Judge.
All right, thank you.
Thank you.
This week.
And Nora, we'll just break once their lunch has arrived. Who is here on Robert Marble?
No, just.
Good afternoon. How's it going?
Good.
All right, is this a motion to revoke? Could I have a stamp for a motion to revoke? Oh, that's okay. Court is calling 2024 CR 5197 State versus Robert Marble. And can I have parties announced for the record for the state? Defense?
Attorney Bill Simmons for defense.
And are you Robert Marble? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Robert Sean Marble who's placed on deferred adjudication in 2024 CR 5197 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on May 20th, 2024 for a period of 5 years? Is that you?
Yes, ma'am.
State?
In Bear County, Texas, defendant Robert Sean Martin did then and there go to report to the supervision officer as directed for the months of July and August of 2024 in violation of condition number.
How do you plead to that? True or not true?
True.
State?
Waiver remaining violation of litigation judge.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Here is your Megan Galloway for the record. The agreement about breach of comprehensive probation is that we ask the court to deny the state's motion and refer the defendant to felony drug court. And if he's not accepted to felony drug court, that will be sent to status.
All right. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record. All right, I see that this is your first motion to revoke. Why are you not being successful in probation?
Honestly, I just wanted to get high. And after I got high, I just kind of just went off the grids, stepped away from my dad's house and just kind of lived on the streets with friends. And it kind of gave me a little too much anxiety with all the extra things that I had to do. And I don't know, I just felt I'm a little nervous.
I mean, do you want to
Stay
go to
away from
prison?
it. Excuse me?
Do you want to go to prison?
Not at all, man.
There's always room at the prison for people.
I understand.
Probation,
Yes.
what are you recommending?
I would recommend a felony drug court referral based on the information that we received this morning. If not accepted, status. Judge.
Does he need an updated TAP evaluation or no? All right, I'm going to give you a choice. Here are your choices. And these are the only choices you have. There's nothing, no other choice. Do you understand? I can continue you. You're going to remain in custody until you're accepted maybe to felony drug court. If felony drug court doesn't accept you, you're going to SATA. So you'll remain in custody for that. Or I can revoke you and sentence you to 4 years.
No, I'll do the evaluation.
All right, the court will deny the motion. Alternate amend conditions to include referral to felony drug court. And if not accepted, then he will go to SATF and he's to remain in custody until transferred either to felony drug court or to SATF.
I'm not sure if we put on the record that in part of the exchange, in exchange for his plea of truth was to TIC the new case.
Is there anything else from either side?
Not for me.
Nothing from defense, Your Honor.
There you go. All right, thank you.
Maybe excuse Your Honor.
Yes. Matthew Salazar.
It's me, Your Honor.
Yes.
Mr. Salazar was scheduled for contested today. In my understanding, talking to the bailiffs that he is at the Bear County Jail in booking, picked up a new number 1.
Okay. All right, Ms. Ferguson on Salazar. Let's recall this. He's in the middle of being booked. So recall it for the week of March 17th. All right, Vashon. Mr. Salazar is coming back on the 17th. He's in booking. Thank you.
I said yes. It should be on the way.
And Nora, once that arrives, we're cutting off.
With the,
Mm-hmm.
yes, ma'am.
Arnulfo Escobar. So were you all able to reach an agreement?
No, Judge.
All right, how long do you expect this jury trial to last?
4 or 5 days.
I'm sorry, what? All right, Norma, I need a jury trial date, family violence, 4 days. The court will not accept any plea bargaining agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, you'll be brought over dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to do a clothing exchange with your attorney. If there's an issue with the clothing exchange, just let the court know.
Will do, Judge.
Thank you.
Judge, I can put it for April 8th.
All right, April 8th.
Excuse Judge?
Yes. Counsel, make sure that you've done an acknowledgement of discovery.
We have, Judge. I believe Angelini was here one setting. We did it.
All right, thank you. Mark Pettis.
We're ready. Thanks.
Court is calling 2024 CR 2594 State versus Mark Anthony Pettis. Can I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense?
Greg Gameray for Mr. Perez.
Okay. All right, and you're Mark Anthony Pettis.
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Mark Anthony Pettis who was placed on community supervision in 2024 CR 2594 for the offense of injury to the elderly with bodily injury on May 28, 2024 for a term of 3 years? Is that you? All right, state.
Yes, Your Honor, we're here this morning on state motion to revoke community supervision. Violation condition number 2. On or about the 9th day of September 2024 in Bear County, Texas, the defendant, Mark Anthony Perez, the then and there illegally used a controlled substance, namely methamphetamine, violation condition number 2. Waive all other violations.
To that, how do you plead? True or not true?
True.
All right, any objection to the state's waivers?
No objection.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you up to 2 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
But there is, Your Honor, 2 alternate conditions of probation for the petition to include DDRF and a mental health evaluation. 0 tolerance on any contact between the defendant and the victim of the case. And the state will also be TIC, a new case of as of 5 CC 00266.
That is our agreement, Judge.
And what is that cause number? What is the offense?
Violation of the
Victim is his dad.
Well, I mean, I said in the order that there's not to be any contact. So what is the confusion?
Yeah, I just respect him because he's my father.
No, I mean, if you respect your father, you don't hit your father. That's what you're on probation for. So I don't know why I should follow your proposed agreement because he's violating the court's orders, and one of the court's orders is no contact.
Yes, Judge.
So
We've talked about that as well, Judge. I believe he's already been adjudicated as a 2-year underlying. And he is aware of that. And that's actually something he did want to do as well, Judge. So
no, but when I tell people no contact, I am, yes.
We did contact the victim case this morning again. He is that he feels he needs in order to deal with that. That's why he's taking the condition.
All right, so I still don't understand what you don't understand what no contact means. Because here's the thing, if you respect your father, then you don't hit your father. Hitting your father is not showing respect to him.
Yes.
And then you come to me and I tell you no contact, and I'm usually very detailed when I say no contact. And I know I was very detailed with you when I said no contact, and you said you understood. So I don't understand why you're disobeying the court's orders.
Your Honor, I was just going through a lot. I'm still going through a lot.
A lot of what?
My mom almost died.
Okay.
You know, that's, I mean,
No, and I feel sorry for that's happening to you, but that doesn't equate to contacting somebody that you injured.
Your Honor, I believe his mom had a stroke.
Second stroke.
And he said that he was wanted to make sure she was okay, and his understanding that.
Even my distance, I was only visiting when my dad was at work. I mean,
No, they're saying you made contact. So that's what that cause number is about. It's not I'm visiting while my father's at work.
Your Honor, we understand. In that case, it's, you know, they're willing to take that into consideration. But if not, then we'll go through the proper channels. But they're asking him, and his dad's asking him to get help. So that's why we agreed to the order.
Well, that's going to be an inpatient help. Do we have an updated TAP evaluation? I mean, it's, any objection to the court review and the court summary?
There you go.
All right, so it's saying that he's tested positive for meth in the past.
Our understanding, Judge, that the wait for the DDRF is 26 weeks.
Mhm.
That the facility itself, you'd be in there for 4 to 6 months.
So I'm going to deny the motion, alternate amend conditions. He's going to go to safety. Or you can also do a referral to felony drug court, and that's going to be while in custody.
And Your Honor, if he decided to ask you to revoke his probation, what would we have to do to do that?
Oh, would you like to be revoked? The most I can sentence you to is 2 years. The least I can sentence you to is 2 years.
No, I don't want to do it. So
I'm
you
sorry,
want to go
what?
to safety? Yes, ma'am. All right, yes, sir.
All right, so
Just
the
wanna
court
make
is
that-
going to deny, thank you, court is going to deny the motion, alter amend conditions to include mental health evaluation in custody, referral to felony drug court in custody. If he's not accepted in felony drug court, then he's going to safety. And is there anything that you do not understand when I say there's to be no contact?
Yes, Your Honor.
No, do you understand?
Yes, Your Honor.
All right, good luck to you.
Okay, I have one question.
Sure.
On the DDRF,
Mhm.
it's what's the time frame on that? She's sending you the safety.
28 weeks.
Okay, the safety, I mean.
Yeah.
Safety's not, so I'll wait 9 months to go?
No, not 9 months to go. That's the length of the program.
Is there safety in San Antonio?
Yeah.
But ask if you. To do my claims? Right. Those are the two options. We're in front of the judge. That's fine. Okay, safety's fine. Okay.
All right, thank you.
Have a seat in the front row.
Your Honor, if I may, since I'm up here, we had asked Juan Lozano to come back on this day to make sure that the mental health was.
All right, just give me 1 second.
Venice,
Yes.
Venice.
There we are. Just 1 second. It's that I'm just calling everybody in order of appearance. Kristen Garcia. Did you ask him to call?
Yeah, it's up there.
Okay, I will get to it.
I was gonna, we're not doing anything. It's just set till April 8th. That's, they were just updating, Judge.
Okay, all right, thank you.
Okay.
All right, Christian Garcia. Just one moment. They don't give me the original one. It's one that has been copied. Let me see. All right, so there's something about juvenile documents, transfer requested. Yes, where are we?
Attorney and I discussed it, and I've disclosed to him what I talked to the juvenile, it was a co-defendant in a sense.
Mhm.
However, the cases that there were co-defendants on, which you guys see it over there, and my understanding, they never received any information or anything additional to that. And I believe that Mr. Martinez can. You tell the
Well,
rest.
it seems to me that we were assuming that because he was a co-defendant and because they were prosecuting him more rapidly, because the juvenile system works differently,
Mhm.
that they could just transfer their crime scene videos, all the things that they had, just transfer them over to us and they give it to me and it's all good. But that juvenile had so many aggravated cases that they actually pled him on some other ones
Mhm.
and didn't really pursue the ones that my client's co-defendant on. So they don't really have much to give us.
Okay,
So I think what has to happen is maybe the state has to send an email to the detective, can you please send us everything you've got on those particular robberies that are in this court?
And that's something I probably need to give a Ray about exactly which ones. I mean,
Okay.
I'm doing most, I think both of us were doing the off from memory today, but I mean, if you don't mind, Judge, if we can go walk the docket and we can actually get together and discuss that until the next set.
All right, I can bring you back on May 5th.
I think that's good, Judge.
All right, so May
I'll be
5th for
ready.
discovery. All right, thank you so much for dressing appropriate for court. Once, just have a seat once your attorney gives you the reset form, you're excused.
Thank you, Your Honor.
Thank you.
It has to be.
And Norma, what page is Christian Garcia on?
Yes.
Thank you.
I'll have to look at it.
Alexis Spang. Right, court is calling 2024 CR 012868 State versus Alexis Spang. Could I have parties announced for the record for the state?
And Brian Powers for the defense, Your Honor.
And are you Ms. Spang?
Yes, Your Honor.
Counsel, have you received all discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Spang, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Any objection?
No objection, Your Honor.
Did you understand in count 2, you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Judge.
Ms. Spang, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 2. There's a $1,500 fine to be probated, affirmative finding of deadly weapon. State recommends deferred adjudication. They're taking in consideration 2024 PF 18473. There's an affirmative finding of family violence, and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be 60 hours of community service restitution, the BIPP course, TAP evaluation, and follow recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to out the offense in count 2, how do you plead?
Guilty.
State any evidence.
State offer states exhibit 1 and all attachments.
No objection, Your Honor.
State, have you spoken with the complainant?
We have not, Your Honor, but we have received what you would like to see.
All right, thank you. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Other than Miss Bang is young, she has no prior criminal history, Your Honor. She was in a toxic relationship, and that's why the no contact order is a good thing. And we're asking the court to follow the recommendations.
All right, any drug issues with you?
No, Your Honor.
Do you have any children?
No.
Do you live here in Bear County?
No, Your Honor.
Where are you going to be living?
Somewhere here in San Antonio.
She is from Pennsylvania, so I don't think she was quite familiar, but this is Bear County, but she will be.
Are you asking for a transfer back to Pennsylvania?
No, Your Honor.
How far did you go in school?
All the way. Graduated.
All right, so what are you planning on doing with the rest of your life?
Working.
Doing what? When's the last time you had employment?
Before I got locked up.
Doing what?
Server at Denny's.
Okay. All right, this is what the court is going to do. The court is going to sentence you to 4 years deferred adjudication. There's a $1,500 fine. That will be probated. There's an affirmative finding of family violence. There's to be no contact with the complainant. Taking consideration 2024 PF 18473. There's to be regular reporting by Zoom or in person, regular random UAs, affirmative finding of deadly weapon, the BIPP course. There's to be a TAP evaluation in custody. Follow TAP recommendations. Proof of employment within 30 days of release, no employment as a home healthcare provider or with minors. There's to be 180 hours of community service restitution. If you obtain some higher level of education or trade school certification, the community service hours will be deemed satisfied. So you can choose to better yourself or pick up trash on the side of the highway. That's what they're having people do now. There's to be field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court in order to be successful in this probation? Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Your Honor, if I may,
Yes.
would she be able to do, she's been in continuous custody since this offense because her family is out of state. They haven't been able to bond her out. Would she be able to do the TAP evaluation out of custody, considering
No.
how many months she's been in?
They'll be able to complete the TAP. My understanding, the TAP will probably be done by next week.
Understood.
All right, thank you.
Thank you.
You're welcome. All right, who is here with the interpreter? And are you ready with the paperwork for the interpreter? Who's your client? All right, I have the paperwork.
Will you approach judge or?
Yes. And probation, this is not an application. Court is calling 2024 CR 010417, State of Texas versus Santo Carcama. Can I have parties announced for the record for the state?
Megan Galloway for state.
Kim Gonzalez for defense.
And are you Mr. Carcamo?
Yes.
All right, and we have an interpreter present. If you could raise your right hand for me. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand and state your name for the record.
Cesar Travis, license number 2203.
All right. Defense, do you speak Spanish?
No, Judge, somewhat
Okay.
not sufficient to interpret for the court by any means.
All right. So, Mr. Carcamo, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
All right, counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Mr. Locke did, Judge.
All right. So the attorney standing in today for, this attorney is standing in today for Mr. Locke. Do you have any objection with this attorney standing in for Mr. Locke?
No, it's fine.
Okay. All right, the court will find that the state is in compliance with discovery. Sir, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, lesser offense of physical bodily injury, class A misdemeanor.
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Just one moment. All right, off the record for a moment. I don't realize in misdemeanor court. All right. Did you understand that the state is proceeding on the lesser included offense of assault bodily injury. The range of punishment is up to 1 year in the Bear County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea. Okay, is there, if the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Because I don't want to be in jail any longer.
Well, no, here's the thing. I don't want anybody to enter into plea bargain agreements because they don't want to be in jail any longer. If you would like, we can recall this back for jury trial, and we'll recall it back this month for jury trial.
No.
All right, so then are you proceeding by trial, by entering into a plea bargaining agreement freely and voluntarily?
Yes,
All right.
voluntarily.
Did you understand by giving up the rights that I've told you about by entering into this plea bargain agreement, you're giving up those rights that the court has gone over with you? The right to jury trial, the right to remain silent, the right to cross-examine witnesses. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Carcoma, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, did you explain to your client or have an immigration attorney explain to your client the impact on his immigration status of entering into this plea bargain agreement?
Yes, Judge. He was advised this afternoon as well as prior to today's plea by his original attorney, Mr. Law. So he's been advised by the firm twice.
All right, thank you. Mr. Carbona, do you understand that by entering into this plea, you will be deported?
Yes.
And did you understand you would not be allowed naturalization and will be denied re-entry into the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes.
According to the plea, punishment is being assessed at 232 days in the Bear County Jail. There's an $800 fine and there are no applications. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
That's correct.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
The state offers the exhibit number 1.
No objections.
Did you review the waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports that There'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge, we're just requesting that the court follow the plea agreement.
And state, have you spoken to the complainant? All right, the court will sentence you to $800 fine. Time and money will not run concurrent. There's 232 days in the Bexar County Jail. There's to be no contact with Walter Hernandez. There's to be no re-entry into the United States. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Good luck to you. Thank you.
Thank you, Judge.
Thank you. Thank you so much. Okay, all right, thank you. Don't give me any more files. Oh, that's how you pronounce that. Angel Palencia. Court is calling 2024 CR 011-483 State versus Angel Placencia. Could I have parties announced?
Gallery for the state.
Joseph Stateson for defendant.
And are you Mr. Palencia? Why were you late?
I was late.
Yes, you were.
Um,
Docket is at 9 a.m.
My mom is pregnant. It's law for us to get out of the house.
All right, so here's the thing. I understand that, and I understand that you're young. I can tell you're super young. But you're gonna have to make sure that you report to probation on time. Otherwise, they're gonna tell me you're not reporting on time, and whoever your probation officer is, they may file a motion to revoke. You understand?
Yes, ma'am.
All right. Counsel, you received all discovery, reviewed it with your client?
Yes, Your Honor.
And Mr. Placencia, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
And did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? All right, let's go off the record for a moment. All right, so, and again, if you all decide this is what you're gonna do, it's still here, I'll accept it. But I can tell you this, you better not get in any trouble
No, ma'am,
between now and when you come back on this, otherwise, you know.
I moved back to parents' house and I work in the oil industry now and I own my own. So
Well, that's something you need to bring to the state about what you're doing now. Did you graduate from high school?
yes, ma'am.
All right, that's good. All right, so how much time do you all want state? All right, and you say you work the
Oil industry, the oil fields.
in all fields. So in this 2-week time, if he's working in the all field and things don't work out the way you perhaps want it to work out, I can take his plea by Zoom. It won't be a problem.
Okay.
All right, so do y'all want to put it for the end of March? All right, so you all want to do March 3rd?
Wait,
I'm sorry, that's April 3rd. Well, you know what? Actually, I see there's a specific trial that's coming up March 31st. Do y'all want to do it March 24th, 26th, 27th, or either the week of March 17th?
Yeah, we could just.
24, 25th.
All right, 25th. Norma, can you recall for March 25th on this case? All right, we'll bring you back on March 25th. Do not get into any type of trouble. You understand?
Yes, ma'am.
All right, thank you. Once you sign the reset form, you're excused and don't be late. Who's here on Juan Lozano? Okay. All right.
Hey, he's out here, Your Honor.
All right, if you'll come up, sir. Sean, do you want it on Tuesday, the 17th? I'm sorry, Tuesday, the 18th, or Thursday, the 20th? Did you said Tacoma is coming up on the 8th of? Oh. All right, so we can bring this back the week of the 14th. We can do that Monday, the 14th. All right, we're gonna bring you back on April 14th. They tell me that they're running the evaluation, so that's as soon as I can give you, okay? All right, thank you so much. Thank you for your patience. Who's here on Richard Flores? Madrigal? All right, where are we on this case?
This is discovery deadline, I believe, Judge. We have that.
Okay,
I believe we have all the discovery at this point.
all right, and was the state able to tender an offer or no?
There was an offer back in January before I was appointed on this case, but there's no updated offer.
Okay. How old are you, sir?
30.
All right, Miss Ferguson, if you'll set this for a plea deadline date, we can do it the week of March 24th.
That's fine.
Okay, let me get a date from her. The week of, yeah, the week of, no, the week of March 24th.
I can do.
All right, March 25th.
Okay.
All right, thank you.
Thank you, Judge.
Sorry, Judge Oakley.
No problem. All right,
Sir?
Timothy Dean, come down. Joseph Macomb.
Judge, I'm here. 1 second.
Okay. Hi.
Hi,
You're-
Judge. How are you?
Oh, I'm doing okay. So how's your flat tire?
Well, Judge, it's still flat. Just been waiting to get this knocked out, but if we could get this taken care of, or if we need to reschedule, because then I need to make arrangements to get the car taken over and get the tire swapped out. So we don't. It's all over the place, Judge. But yes,
Tell you, they don't make
I need to
cars
check.
the way they used to make. Used to you would have a full tire
That's right.
that you can change
And-
it yourself. Then they went to the donut tire, and now it's you don't get a tire.
Well, Judge, growing up with my father, my uncles, everybody could work on their cars, and now there's no way. I mean, you have to have the specialized tools, and it's so compact in there. But yes, it's different than it was.
All right, so we had an issue with his
Okay.
tire. So, like, if I reset this council, it would have to be on, the soonest I can set it is March 17th.
Well, I think the hearing judge is on the 20th. And I don't even know, Judge, if Tim is on the feed or if he's not.
Oh, he's right here.
Okay. What I'm trying to coordinate with this judge is a matter out of Guadalupe County. And if you recall, I had mentioned that on Monday that I'm trying to come up with a plan actually that may work for everybody, that ultimately would benefit Tim. But of course, I need the time and the latitude to make sure that everybody understands what I'm proposing and that they're on board with it. The MTR is, your all's MTR only has a few conditions violated. The county court 6 is just, I think there's 3 pages worth, but most of those are just repetitive for the same violation. But Judge, as far as the bond hearing itself, I mean, all we were trying to do is to get a bond set.
All right.
This may be
We
problem.
can go forward. If your client is fine with you appearing by Zoom, we can go forward on a bond.
That's all it was, Judge, is just to get a bond set on the MTR out of your court.
Have you talked to the state to see if you all have an agreement?
No, Judge, I haven't. That all of this was to have taken place this morning, and then I had these car issues.
All right.
I was just. There's these recipes for the SGR and the violations. The violation officer.
All right. So with regards to the reinstatement of bond, you're saying the previous amount of the bond, because I can't reinstate.
I got you, Judge. It just to set a bond for him. I misspoke. If we could get a bond set, I believe he's remanded without bond right now out of your court on the MTR. County Court 6 has set a bond amount at $10,000 with the conditions of GPS and Scram.
All right, let's go on the record. Court is calling 2020 CR 0375W, State of Texas versus Timothy Joseph Dean. Can I have parties announced for the record for the state? Defense.
Joseph Macomb, counsel for Timothy Dean.
And are you Mr. Dean?
Yes, I am, Your Honor.
All right. The defense is requesting a bond be set in this matter. You're entitled to a bond because it's a deferred adjudication. State, what amount are you agreed to setting the bond at? All right, defense. The state
Judge-
said they're in agreement to a $15,000 bond.
Um, Judge, that would be fine. And then the conditions out of County Court 6 would be imposed anyway. So, Judge, we're in agreement with that.
All right, because you're on deferred adjudication and on probation out of this court, the court is aware of the issues that you have and the appropriate conditions that will be set with this bond. Did you file a motion to set bond, counsel?
No, Judge, I had just walked in well, actually, I came in last week and then I was able to catch you on Monday. But I didn't file a formal motion, Your Honor. I just approached.
All right, any objection to proceeding on an oral motion to set bond? All right, then the court will set your bond at $15,000. Full GPS. Waive fees. Ms. Ferguson, counsel tells me this is already set on on March 20th. All right, we'll see you back on the 20th. Norman, if you'll give him a reset form so he'll know to be here. All right, thank you.
Judge, thank you very much, ma'am.
You're welcome. I hope everything works out.
Thank you very much.
All right,
You have a great afternoon.
thank you. All right, court is going on recess.
Did we also have Sinwell?
Okay, who is that? Let me find them on the docket. Oh, the ones where people say that their attorneys are in jury trial, I will take care of that.
Kenneth Baker.
All right, just give me one moment. What page is Dean on? Okay.
And did you know we have a verdict, right?
We do?
Yes.
Nobody told me there was a verdict. No. All right. Bring in the defense attorneys. I've just been waiting like, oh, thank you. Nobody's told me. Or did you just come by and do the V sign? Oh, I didn't see it.
And that was it.
All righty. All right, they'll, when you get a chance, if you can take them back and.
Reset. Waiting for judge.
No, I had no idea.
Your Honor, are we excused or are we just coming back after?
Oh, we're gonna come back after lunch and we will be back at 2:30.
She don't want to reset her, she just reset.
All right, what is her name?
Last name was Sinwell. Constance.
All right, your client is in jury trial, so we're gonna bring you back on.
Her attorney?
Yes, her attorney's in jury trial. I'm sorry, it's been a long day. All right, we're gonna bring you back on March 20th. Thank you. You're welcome. Yes, sure.
You guys take it back here? No, she said, well, we're taking it right there.
I asked her us whenever.
Yeah, they're both done. Yeah.
So we're gonna have two people that are all on.
Okay, I'll take care of that after I do this. Just give me a moment. Yes, we'll be back at 2:30. I'm sorry? Oh, I am so sorry.
Yeah, please.
All right. All right, so guys, on page 1, Kawazawi, 417. Ruiz, 5-5. Moreno, dismissed. Saucedo, sentenced. Parmala, sentenced. Akuro, All right, I'll take care of it. 2:30. Placencia, 325, Esquivel, 48, Madrigal, 2:30.
My problem is taking care of Judge. He said 3:25.
All right, thank you. Grant, 2:30. Quintanilla, 47, Trevino, 320, Aguilar, 51, Perez, 51.
You have 5:5.
I'll check it later. It's 5-1 for now, though. Martinez, 2:30. Oh, you're right, it is 5-5 because it's Cinco de Mayo. Thank you. Salinas is 4-7. Spang, that's done. Sinwell, 320. Marrero, 327. Mejia, 5-5. Anderson, thank you, 2:30. Taylor, 2:30. Miller, 3:18. Ashmore, 2:30. Castro, 2:30. Mariscal, 4:17. Dean, 3:20. Lozano, that's completed. Castillo, withdrawn. Nicholson, 2:30. Flores, 2:30. Pavala, 3:18. Johnson, 2:30. Cooper, 2:30. Gibson, 3:20. Salazar, 3:17. Perez, that's completed. DeLeon, completed. Martinez, 3:20. And Marble, completed. All righty. Thank you, guys. All right, we're going to go on the record. We're going on the record in 2023 CR 9068 State versus Jose Lopez. Could I have parties announced for the record for the state? Defense.
Juror Robert. Power for the defense.
Order. And are you Mr. Lopez? Are you Mr. Lopez?
Yes, ma'am.
All right, the court has received word that the jurors have reached a verdict, so the deputy will line them up and we will take the verdict. Yes. No, no, we're not going to stand to receive the verdict. All right, we're ready. Okay. All right, it's the court's understanding that you have reached a verdict in this matter. Is that correct? And is the verdict unanimous? All right, if you'll tender the jury charge to the deputy. Thank you. All right, count one. It states, we, the jury, find the defendant, Jose Lopez, guilty of the offense of aggravated robbery as charged in count one of the indictment. Count two, we, the jury, find the defendant, Jose Lopez, guilty of the offense of aggravated assault as charged in count two of the indictment. Deadly weapon. Answer, we find beyond a reasonable doubt that a deadly weapon, namely a wooden object, a metal pipe, or a glass bottle was used or exhibited during the commission of the offense in count two. And we find beyond a reasonable doubt that the defendant, Jose Lopez, used or exhibited said deadly weapon, namely a wooden object, a metal pipe, or a glass bottle during the commission of such offense in count two. Is there anyone who wishes to have the jury polled?
Not the defense, Your Honor.
All right, thank you. All right, ladies and gentlemen, what I'm going to do is I'm going to give you your lunch break. Food has been ordered for you. You are not allowed to discuss this case during your lunch break. Does everyone understand? What will happen is I will bring you back in for phase two of the trial. That is the punishment phase. And either party may present evidence to you. You understand? All right, thank you. All right, everyone, with regards to this, I do have a docket at 2:30. So we're going to resume this at 3. So if you all state if there's fingerprinting or whatever, then motions will need to be filed. The court will hear if there's any objection. Otherwise, there'll need to be fingerprinting done during that time frame.